All right. Good afternoon, everybody. Welcome to House Economic Matters. Today is the 13th of February. We have 5 bills, a total of 55 oral witnesses, so it'll be a longer day. The first bill will be one of our own, House Bill 611 by Delegate Harrison.
Good afternoon, Mr. Vice Chair Crosby and members of the Economic Matters Committee. For the record, I'm Delegate Andrea Fletcher Harrison, and I'm sponsoring HB House Bill 611 on behalf of the Attorney General, and this will repeal the Electronic Transactions Protections Act. This bill was passed by the Maryland General Assembly in 2001. At that time, electronic transactions meant something much different than they do today. We are sending information electronically through, sending through fax machines and copied pages of paper. But today we're sending information and transferring money using cell phones, emails, and various online apps. We're now worried about cybersecurity. So certainly we've come a long way since 2001. That particular unit was established by this act, but it was never developed or funded. Therefore, the original sponsor of the bill, which it was enacted in 2001, it was this very young delegate, his name was Anthony Brown, would like to repeal this act because it's no longer necessary. Therefore, I am requesting a favorable vote on HB 611 by this committee. And that young man, who may not be quite so young anymore, is here joining me. And if it's all right with you, and Mr. Vice Chair, I'd like to turn it over to him.
Yep, go ahead to the senior gentleman. Go ahead.
Thank you, Mr. Chairman and members of the committee. And I will be testifying later on HB 567, one of the online data privacy acts that you'll be hearing later today. And I'll talk a little bit more about this unit. Let me just say that, 13 months ago, I was sworn in as the Attorney General, and in doing my due diligence, both before and during that transition, looking at the authorities and the responsibilities of the Attorney General, I noticed in the state government article, then the Office of the Attorney General, there is this unit called the Electronic Transaction Education, Advocacy, and Mediation Unit. I said, who are they? So I went to my Consumer Protection Division. I said, who are they? I'd like to meet them. They said they don't exist. So I was talking to my team and I said, how could this happen? Yeah, the legislature created this unit to do good things on behalf of the Maryland. Like who sponsored that legislation? What was that legislator thinking? Didn't follow up to make sure that the Office of the Attorney General actually implemented this authority. So my team went back, they took a look at the legislative history and they said, Delegate Anthony Brown sponsored the bill in 2001. And the only excuse I can offer is that a month before it went into effect, there was 9/11. And I think, we probably all took our eye off the ball. But this is a unit that is in the article, the state government article. It does not exist. We're going through, we're cleaning up the code. We're trying to clarify to Marylanders what we do and what we don't do. And right now, we do not do electronic transaction, education, advocacy, and mediation in the Office of the Attorney General. Now, I am going to come back in House Bill 567 and propose what we should be doing by way of an amendment to that bill. But for now, I would ask that the committee repeal the Electronic Transaction, Education, Advocacy, and Mediation Unit in the Office of the Attorney General. We have no resources, nor does it give us clear authority to truly do anything on behalf of Marylanders. Thank you, Mr. Chairman.
Thank you. And I do not see any questions. Oh, I apologize, Delegate Weibel.
Just one question. So there's no fiscal impact, no money's ever been allocated or budgeted for this unit?
That's correct. No money has ever been allocated for this unit.
Okay, thank you.
Okay. Seeing no other questions, that officially concludes this bill hearing. Thank you.
I just wanted to thank the sponsor for carrying this heavy piece of legislation for us, but very important and vital. Thank you.
And
Right.
thank you. I just want you to know that this is my constituent.
All right, next, I believe we have House Bill 622, and we have Delegate Healy's aide coming to testify. Okay, do you have a panel? Did you want to bring them up?
No,
Okay, go ahead. You can start when ready.
I'll sit right here. Okay, good. Thanks. Good afternoon, Chair Wilson and members of the committee. For the record, I am Emma Johnson, testifying on behalf of Delegate Ann Healy today, seeking a favorable report on House Bill 622. This bill simply requires that a consumer reporting agency not include information from a criminal proceeding where persons are falsely accused, acquitted, or exonerated, as well as dispositions that are dropped, nol pros, not guilty, or expunged. This does not refer to obsolete information. This bill came before your committee last year with testimony stating that federal law would preempt this legislation. This testimony was not from the Office of Policy Analysis. I have attached 2 Attorney General's opinions regarding this issue, addressing an interpretive rule that was issued explaining that the preemptive scope of the Federal Fair Credit Reporting Act, FCRA, is narrow and targeted, and concludes that if a state law prohibits consumer reporting agencies from including information about arrest records in a consumer report, such a law would generally not be preempted. I asked for this opinion regarding last year's bill, House Bill 994, which contains a similar language as this year's bill. The Fair Credit Reporting Act, Title VI, requires that consumer reporting agencies adopt reasonable procedures for meeting the needs of commerce, which must be fair and equitable to the consumer. Because a consumer report has a bearing on a person's creditworthiness, as well as their character and general reputation, it is neither fair nor equitable that records of arrest that do not result in a guilty conviction or dispositions that are dropped, nol pros, not guilty, or expunged preclude persons from the justice to which they are entitled. Justice delayed is justice denied, and this bill would eliminate the unintended consequences of allowing misleading criminal procedures to remain on a person's consumer report. Innocent people are being harmed. Their reputation and livelihood are being damaged. This bill does not preempt federal law, but goes above and beyond to protect the consumers of the state, and therefore I'm asking for a favorable report on House Bill 622.
Okay, thank you so much. You did a great job. Seeing no questions, we have 1 witness in favor. It is William Steinwedel. Come on up, sir. You can begin when ready.
Hello, Chairman and the rest of the Economic Matters Committee. My name is William Steinwedel. I'm the supervising attorney for the Maryland Legal Aid Bureau Foreclosure Legal Assistance Project, and we testify in strong support of this bill. Most credit reports, most of the standard, the Equifax, Experian, and TransUnion credit reports, which are the 3 largest credit bureaus, mostly don't report this information. However, a lot of landlords will seek out their own independent credit reports, and with the increase in publicly available information, it is much easier now for these non-convictions, nol pros, not guilties, and expungable offenses to be still found on publicly available information sites. So because of the increase in technology, we think this bill is very, very important and needs to be passed. In addition, if a person were, this bill would bring the credit reporting industry and the credit reporting information available in line with what is the policy of the Maryland courts. If anyone were to testify before the Maryland courts, the only crimes that could be used to impeach their testimony would be guilty findings, number 1, and guilty findings of crimes of moral turpitude or of serious violence. So if it's good enough for the Maryland courts not to consider when a person's, considering their testimony, or for a fact finder to consider their testimony by not considering these charges, I don't believe a person's credit should be determined by these charges either. So for those reasons, the Maryland Legal Aid Bureau wishes to have a favorable report on this bill. Thank you.
All right. See, well, Seeing no questions, that concludes this panel on this bill. Delegate Pepe.
Sorry.
Yeah, go ahead.
So I think it goes without being said, the a null pros is a lot different than falsely accused, acquitted, and exonerated, but I'm not gonna wear you out about that. You may or may not be aware, in many cases, individuals are charged with multiple offenses and they tend to null pros a couple of those in an effort to get a plea deal or something like that. But my question is, how many places are seeking out this additional information above and beyond just like a standard credit report? Is that typical practice now where they're going on to case search, like Maryland case search, or they're going to LexisNexis and pulling up info? If you could just elaborate on that a little bit, that'd be helpful.
We believe that most landlords and most creditors have attorneys who generally have access to Westlaw or LexisNexis, which provides a public benefit search. I mean, people do it for employment. I'm sure that they do it for everything else as well. When I used to work in the creditors industry, my employer had me pull information for people that had applied for jobs, so I'm sure it's happening. That much I can be sure of.
So I just want to understand, and then I'll stop. So it would prohibit anyone from, in addition to going on to Experian or TransUnion or Equifax, from, let's say, going to case search and just typing in that name, printing it out and including that in an application?
That's correct. In addition, case search no longer reports null process or not guilties. So if they just went on the case search, they couldn't find that information anymore. So they would have to go to an additional source. So this just prevents them from doing that. My understanding is this prevents them from doing that so that they can't use it to make credit decisions.
Gotcha. Okay, thank you.
All right, seeing no questions, this concludes this bill panel and the hearing. Next, we will go to Delegate Lewis, HB 645. I do not see Delegate Lewis. Delegate Solomon, House Bill 603. Oh, they do not want to be caught behind this next one.
He's testifying now in appropriation.
Okay, we will go to House Bill 567, Delegate Love.
Thank you, Mr. Chair. May I bring up my panel? Okay, Holly, and then Paul. You can testify with the Attorney General. Okay. It's up to you. I'd love to have you here too. Why don't you say it? Thank you, Mr. Chair, members of the Economic Matter Committee. Good afternoon. I'm Delegate Sarah Love, here to present HB 567, the Maryland Online Data Privacy Act. Right now in Maryland, we have no comprehensive online privacy law, and that's a problem. Companies are collecting and selling our personal and sensitive information without our knowledge or consent. When you download that free app, that app isn't free. You're paying for it with your personal information. A recent study showed that at least 70% of mobile apps share data with third parties. That data could be our mental health data. It could be our location data. It could be data about a child. And I want to give you a short example. When my brother-in-law was sick prior to his passing, he was making an appointment with the doctor's office, and the doctor's office wanted him to do it through their online portal. So he did. And the next day, my sister received an ad on Facebook for that doctor's office. How many of us, when we make a doctor's appointment and we have to say what the appointment is for, think that information is going to Facebook? The global digital advertising market is a $6 billion a year industry, and we are the product. Now, some of you may be horrified by that, and some of you may think that's fine. And that's where HB 567 comes in, because it gives you, the consumer, the right to say what is collected and how it is used. Love those targeted ads? Great, you can get them. Hate those targeted ads? You can opt out. So I want to give you four sort of overarching themes in the bill. So first, it gives consumers control over their personal data. We have the right to know what is collected and with whom it is shared. We have the right to correct the data, delete the data, opt out of targeted ads, the sale of data, and profiling. Second, it has extra layers of protection for what is defined as sensitive data. So data that reveals racial or ethnic origin, religious beliefs, health data, biometric data, precise geolocation data, and data that the controller knew or should have known was from a child. Third, it provides that companies only collect and process the data needed for the transaction at hand. For example, when I'm playing my solitaire game on this app, there's no need for my location to be collected and sold. So first of all, companies should not be gathering all our information for their own profit without our knowledge and consent. And second, collecting all of this data and building these online profiles puts us at risk. Last year, the Attorney General's office received notice of over 600 data breaches. And that information was credit card numbers, financial numbers, medical information, all sorts of information. Worldwide, there were over 8 billion cyber attacks and breaches. And finally, it puts in security measures for the data protection. The data that is gathered has to be kept secured. The contracts that the controllers go into with the processors also have to contain guardrails. So in closing, the devil is in the details. Prior to sending this bill, I sent it to 17 stakeholders, including the opponents here today. And I took 32 of their amendments. There was a recent report out talking about privacy bills across the country, and almost half of them received a failing grade. This bill gets a B-. Not happy about that grade, but it shows that it's a compromise bill. I would like a private right of action, but it's not in there. I would like consumers to be able to opt into the collection of their data, but that's not what this bill is. So it's a compromise bill. I will take that B- and respectfully request a favorable report. Thank you. Who wants to go next? John?
Chair Wilson and members of the committee, thank you for the opportunity to testify in support of HB 567. I'm John Davison, Senior Counsel at the Electronic Privacy Information Center, or EPIC. I also grew up in Maryland. EPIC is an independent nonprofit founded 30 years ago to secure the fundamental right to privacy in the digital age. Earlier this month, as Delegate Love mentioned, EPIC and US PIRG released a report on the state of privacy laws. That state is not good. Of 14 states that have passed consumer privacy legislation, nearly half received failing grades and none received an A. Connecticut, the model that industry groups are pushing in Maryland and other states, got a D on our scorecard. Unfortunately, Connecticut's law allows businesses to continue collecting and using whatever personal data they want, as long as they bury what they're doing in a long privacy policy that no one will read. This is fake privacy protection, something that may look like a strong privacy law to the untrained eye, but in reality just greenlights a harmful type of business as usual. The Connecticut model is wrong for Maryland, and EPIC commends the sponsors of HB 567 for instead setting strong limits on the amount of personal data companies can collect and how they can use it. This principle is called data minimization. HB 567 would permit businesses to collect only the personal data reasonably necessary to provide the service a consumer asks for. And that standard is higher for sensitive data, such as location and health data, in that it must be strictly necessary. This better aligns data practices with what users expect. So if I give a weather app access to my location, they can use that data to give me the weather and other necessary purposes that would make sense in context. But they can't store my location data forever, and they can't sell it to a dozen data brokers. HB 567 takes off some of the onus from consumers to protect their own privacy and instead sets meaningful limits on mass data collection and use. Importantly, HB 567 also extends civil rights protections to online spaces by prohibiting entities from processing data in discriminatory ways. In our written testimony, we suggest additional ways to strengthen the HB 567, and we are happy to be a resource for the committee as it works on this important legislation. Thank you.
Good afternoon, Mr. Chair, members of the committee. Thank you for the opportunity to testify. I'm Dr. Greg Von Layman, staff to the Maryland Cybersecurity Council, a statutory body that's chaired by our Attorney General, who's here this afternoon. I'm here to support HB 567 as consistent with recommendations of the Cybersecurity Council. So I'd urge a favorable result for 3 reasons. First, the bill provides much needed risk management tools for consumers, and that's the way I frame it. A report published by the Maryland AG's office last year indicates that in fiscal year 2022 alone, were almost 1 million separately reported Maryland residents affected by more than 1,300 data breaches. The consumer rights in this bill to know, to delete, to opt out of the sale of personal data are tools that can enable consumers to kind of shrink this exposure. So we're talking about the prospect of less ID theft, fewer financial account takeovers, extortion, and on and on. And second, as has already been pointed out, this bill benefits from national experience. There are now 14 states that have at least what the International Association of Privacy Practitioners calls comprehensive consumer privacy rights legislation. And this is a bipartisan effort. California, of course, was the first, but in the mix, we have Texas, Tennessee, Virginia, Delaware, and a number of other red and blue states. For sure, there is some variation among these statutes, whether or not they have the right of private action is one example. But in core respects, they are very similar. House Bill 567 is informed by this experience. It's a good bill for Maryland. And finally, the question is, if not now, my count, this is the 5th session of the General Assembly that a comprehensive consumer privacy bill has been proposed. Given the risks, Maryland residents deserve to be allowed a greater role in reducing their exposure to breaches and the consequences. House Bill 567 would do this. The time is now. Thank you.
Good afternoon, and thank you, Chair Wilson and members of the committee. My name is Holly Grosshans. I'm a senior counsel for tech policy at Common Sense Media. We are an organization that promotes education and tech policy to protect kids and families online. I'm also a mother of 2 elementary aged kids, and I care deeply about their privacy and the well-being of my own kids and the millions of children like them who are depending on this committee and this legislature to establish desperately needed protections for their online safety, privacy, and overall well-being. Common Sense Media strongly supports the Maryland Online Data Privacy Act of 2024, HB 567. And also for the record, Common Sense supports the Maryland Kids Code, HB 603, which you're also going to hear about later today. For far too long, online rules that purport to protect young people haven't actually protected them. Teens and children are particularly vulnerable to practices that are used by social media companies to exploit their personal data. This privacy bill protects basic and desperately needed privacy protections, not only for kids, but for the people of Maryland. These are protections that are afforded to people that live in other states and are not being given right now to the people of Maryland. We are especially pleased that this bill fills the gap in outdated federal law by protecting children and teens. Specifically, this bill includes strong protections against the sale of the user data and targeted advertising for all Marylanders. It also includes heightened protections for young people that will prevent companies from pretending that they don't have kids on their sites. And third, it includes new protections for teenagers' privacy, which under current federal law, they are unprotected. Those privacy protections as much as those in any state. We unambiguously support this bill and urge the committee to move it forward. Thank you for the opportunity to testify today.
Good afternoon, Vice Chair Crosby, committee members. My name is Hannah Abrams, and I'm here on behalf of the Consumer Protection Division of the Office of the Attorney General. Maryland consumers need a comprehensive privacy law to address the unprecedented business practice of widespread personal data collection and distribution. In the past several years, we've witnessed an ominous trend of large companies across the nation gathering and sharing sensitive information, often without the knowledge of the consumers themselves. At this point, 14 other states have taken action to protect consumer privacy, and it's time for Maryland to do the same. House Bill 567 contains a number of key provisions. It requires companies to be more transparent about their data collection and use practices. It requires companies to limit the data they collect, which limits the misuse and potential accidental release of personal data. It restricts companies' use of sensitive data, and it provides consumers with individual rights in connection with their personal data. We also note that unlike prior privacy bills that have been introduced to this committee, enforcement of HB 567 resides solely with the Consumer Protection Division. The division supports HB 567, but urges the committee to limit the exemption for financial institutions and their affiliates. While the Leach Blythe Act provides customers with some privacy protections, those protections only extend to customers. Moreover, the exemption extends far beyond financial activities to affiliates that have nothing to do with banking. In my written testimony, the division proposed a narrower exemption that would cover financial institutions and insurance providers as defined by the Maryland Code. With the amendments identified in our written testimony, we urge a favorable report. Thank you.
Thank you. Ma'am, just to confirm, you're favorable with amendments? Okay. All right, Delegate Queen.
Thank you, Mr. Chairman. So I want to thank the sponsor for her tenacity with bringing this bill back 5 years, and hopefully this will be 5 years to charm, maybe. I do agree with your opening statement that Maryland needs a online data privacy act, and I think this is long overdue. But with that said, I still have questions. The first question is with the Office of Attorney General. So you mentioned your exemptions that you have with amendments. You also had amendments related to definitions and controller obligations. Is that also something the sponsor is interested in putting in the bill? Or are you familiar with these?
I am familiar with these, and if that is the will of the committee, I would support that.
Okay. You also have amendments favorable with amendments from the state treasurer. We understand that this is not related to state employees, but I think they used the term the instrumentalities of the state was what they want the wording to be. Are you familiar with that, or any concerns about that?
I am familiar with that. And given that it is the state treasurer, I will leave that to the wisdom of this committee.
Understood. Also, you have favorable with amendments. I do read your bills. You understand that. From the National Crime Bureau, which talks to, I think, exempting non-profit entities. Are you familiar with that or have any concerns about that?
I am familiar with that, and I have spoken to them extensively, and their concerns are addressed in the bill. I've talked to them multiple times.
Okay, so we need to see if they believe that, I guess. Okay, thank you for your time.
Thank you.
Quick question about loyalty reward programs, because that has come up, I think, every time that we have debated some type of privacy bill. And I've had 3 meetings on loyalty reward programs. The bill in and of itself doesn't ban loyalty rewards, correct?
It does not.
Okay, and so when opponents come and I guess want to discuss that topic, right? Because like I have my Starbucks rewards, right? Or my Safeway rewards or whatever other rewards. What section of the bill are they even talking about or trying to point to? And I'm not trying to throw or lob a huge net here, but if you know what they're trying to get at, it would be helpful.
I do know what they're trying to get at, and it's mostly that the section of the bill, and I could take a couple minutes to find it if you want, but it deals with charging different amounts for loyalty programs. And the bill exempts that because what the bill is trying to say is if a consumer exercises their rights under the bill, they can't be charged a different amount. However, if you have a Starbucks card and you get a certain amount of points and you get a free drink, that's not what we're talking about. That doesn't apply here. So I think that's what they're getting at. And if there is a tweak to the language to make that clearer, I am certainly happy to talk to them and look at that.
So is that, I think it's the bottom of page 19. It begins with the controller may not, and then it's section 7 on page 20, line 16 to 20. Is that what they're getting at?
Not on, well, then page 19, I think they had a question about I don't know that that's the section
Okay, I mean,
that
I
they're
know
talking
that
about.
then you go down to 21, and you don't have to answer this right now, but I would like to just know what the argument against this would be on page 21, 27 to 31. It begins with prohibit a controller from offering different price rate. I mean, maybe that's what they're trying to
I
clarify.
think that's what they're looking at, and it's,
Okay.
it's, so nothing says that a controller can't charge a different price if it's part of a voluntary participation in a loyalty program. So it's saying the controller can.
Yep.
It's a double negative.
Yep. Okay, I got you. All right. Delegate Aaron's.
Thank you, Mr. Chair. Out of all the bills you mentioned, all the other states that are doing this, which state does this bill most resemble?
So it was modeled off of Delaware. So that's the one it most resembles.
Is there any way we could get like the differences between that bill and this bill?
I can give them to you. Sure, I can do that.
I think we might be interested just to see what we're competing against with Barry. If you don't.
Okay.
Thank you.
Sure.
Thank you, Mr. Chair.
All right, seeing no other questions, this concludes this panel. We have one favorable virtual witness. His name is Mr. RJ Cross. Delegate Love, you're good.
Okay, thank you, sir.
Yeah. Is he what? Oh, okay. He's coming online. Let's just. All right, here he comes. Oh, I apologize.
Good Lord, I'm sorry for that. My Zoom just plumb
good.
froze up.
Okay, go ahead and start.
For sure. Thank you so much. Thanks, Chair Wilson, and the rest of the committee. I'm RJ Cross, the director of Maryland PIRG's Don't Sell My Data campaign. Maryland PIRG is we're a state-based, small donor-funded consumer advocacy group, and we are favorable for this. I'm sorry.
I apologize. Okay, go ahead and start. Wait, do you have the YouTube up, ma'am? Do you have the YouTube up?
Small donor funded consumer advocacy group.
All right.
I'm so sorry.
Man, we can hear you. If you have the YouTube up, go ahead and mute that or close that window and just use the Zoom.
All right. I'm with you. Did you hear my first little bit? And I'll just get into it.
It's okay.
All right. Well, I'll just get going then.
Yep.
I'm with Maryland PIRG. We're a small state-based donor group that's around the state. And we're one of the groups that gave HB 567 a B- score in that scorecard. And we are favorable for this bill. So y'all probably have heard that right now we live in a data wild west where companies can gather just about whatever they want from consumers. Now, in 2022, to give you just one example, the fast food chain Tim Hortons was found by Canadian authorities to be using that mobile ordering and loyalty app to harvest the location data of customers 24/7, even when the app was closed. And that just doesn't make sense. Every piece of information companies gather, and the more companies they sell and share it with, the more likely it is that your information is going to end up exposed in a breach or hack and end up with identity thieves and fraudsters. And right now, Maryland has the opportunity to do something better. 14 states so far have passed comprehensive consumer privacy legislation, and most of them are so industry friendly, they do very little to protect the consumers that they're supposed to protect. Take Connecticut, for example. Epic has mentioned some of the weaknesses there. that companies can do whatever they want with your data and collect whatever they want, as long as they put it in a privacy policy that A, no one reads, and B, if you do, it is so vague that it means next to nothing. Maryland here has an opportunity to put in real protections that limit what data a company is allowed to collect up front. And it requires that for sensitive data, things like health or geolocation, that it cannot be used for any other purposes when a consumer is expecting. Maryland PERG would love to see that latter provision strengthened to make sure that that protection applies to all data that is collected. But we, as are currently, respectfully request a favorable report. Thank you.
Thank you, RJ. Seeing no questions, that concludes the favorable witness. Now we'll go to favorable with amendments. I'll start with the Attorney General, Brown. And if you want to bring up both Steve and I guess Hannah already testified. So go ahead and when you're ready, sir.
Good afternoon, Mr. Chairman, and members of the House Economic Matters Committee. For the record, I'm Attorney General Anthony Brown, and I support HB 567 of the Maryland Online Data Privacy Act of 2024 with amendments, not the amendments that Hannah Abrams testified to on the last panel, but this amendment. The amendment would replace the dormant, toothless electronic transaction education, advocacy, and mediation unit in the Office of the Attorney General with the online privacy protection unit that would enforce the provisions of House Bill 567. Mr. Chairman, in 2001, as a freshman delegate and member of this committee, I pre-filed House Bill 14, a bill entitled Information Technology and Consumer Privacy Protection Act of 2001, way ahead of its time. HB 567, the bill that is now before the committee, is in many ways the 2024 version of the bill that I sponsored and Governor Glenn Denning signed into law in 2001. But times have changed since 2001. The world, the internet, the online marketplace, and community are vastly different than they were 23 years ago. In 2001, the bill used terms like World Wide Web and electronic transaction, while today HB 567 uses terms like dark pattern, de-identified data, and geofence, which weren't even in use 23 years ago. When my bill was passed in 2001, it was 2 years before Facebook, 4 years before YouTube, 5 years before the first tweet, and 9 years before Instagram. A lot has changed in 23 years. But what we tried to do in 2001 was to draft a bill that would protect the privacy of individuals' personal information and protect the public from unlawful conduct or practices. And that's what the bill before you today seeks to do. In 2001, the General Assembly created a unit within the Office of the Attorney General to enforce the provisions of my 2001 bill. The House watered down the bill from what was originally filed. And to this day, the Office of the Attorney General has never established a unit to protect Marylanders against online privacy invasions. When I took office last year, I asked a simple question: why wasn't the unit ever established? The answer: we never got the resources and we never got the clear authority to enforce the consumer protections originally intended in the 2001 bill. In 2001, the Online Privacy Protection Act had a fiscal note that included 1 administrator, 4 forensic investigators, and 1 educational specialist to perform the consumer advocacy, educational, and investigatory requirements of the bill. In this year's bill, HB 547 requires the Office of the Attorney General to enforce a statute that regulates a much more complex world in which personal information is obtained and consumer transactions occur. HB 547 requires the Office of the Attorney General to conduct investigations and evaluate data protection assessments conducted by entities that gather and process incomprehensible volumes of data at the velocity of a fire hose with a potentially overwhelming variety of data formats, and to make determinations about compliance with this new law. Today, the Office of the Attorney General is unable to do that work, but we can do it with the appropriate resources and authorities. It is important to note that HB 547 does not include a private right of action, and I do not appear before you today to take a position on whether it should or should not. But keep in mind that such a right would truly ensure that more consumers were protected under this bill. As drafted, HB 547 only authorized the Office of the Attorney General to protect all Marylanders. It's our responsibility that you will give us in HB 547. I cannot do that without the resources and without the online privacy protection unit as established in the proposed amendments. We've sent them electronically to all of your offices. We've walked a paper copy around to your offices, and you will see that it basically replaces that 2001 toothless unit with a real robust unit to meet the needs of 2024. So I asked for a favorable report of HB 567. Yeah, I've been saying 547 all along. Bring you back to this. Thank you, Steve. 567, but only as amended and contingent upon the necessary appropriations. Thank you, Mr. Chairman.
Thank you. Seeing no questions for the Attorney General. Appreciate it, sir. Thank you so much.
Thank you.
All right. Oh, Steve, did you
No, I'm just here to second what my boss said and
keep him in line?
answer any questions.
Yeah.
That's it.
Make sure I've got the right House bills
Yeah.
in front of me.
That's right.
We're aware you had a senior moment. Okay. Next, we will go to Jason Weintraub, Luke Pinton, Robert Enton, Matt Schwartz, and Jamie Gregory. Start when ready. And Mr. Pinton, you just graduated law school or passed the bar, one of the two, probably both.
I did.
Congratulations.
Thank you for remembering with Delegate Pippi as well at the same time. Good afternoon, or should I wait for?
No, they're out of breath already. Come on up to the table, Bob. Go ahead and start, Luke.
Good afternoon, Vice Chair Crosby and members of the committee. My name is Luke Pinton here on behalf of the League of Life and Health Insurers of Maryland. I want to thank Delegate Love for bringing this bill and for engaging in the important work of ensuring that consumer data is kept safe and secure. The League and our members are committed to working together with all stakeholders on privacy legislation to ensure sufficient protections for Marylanders while also enabling carriers to provide services to members in the state without any unintended consequences. Currently, the bill's provisions do not extend to several entities already subject to strict federal privacy laws, such as Title V of the Graham-Leach Blythe Act. The League respectfully requests that these listed entities also include those required to follow HIPAA protocols. A HIPAA entity-level exemption alleviates the heavy burden and financial costs of developing nuanced processes around data mapping and publicly facing disclosures, functions that serve to shield from disclosure information already subject to HIPAA requirements. For this reason, 9 of 13 states that have passed privacy laws have included an exemption for HIPAA-covered entities and business associates. I would again like to thank the sponsor and this committee for your consideration of our position on this important legislation. I'll turn it over to Mr. Weintraub.
Thank you, Luke. Good afternoon, everybody. Jason Weintraub here on behalf of the Maryland Bankers and the American Property Casualty Insurance Association. Favorable with amendments. We echo the same provisions raised by Mr. Pinton. We would like to see the Graham-Leach Blythe exemption expanded to include the data for those companies subject to that federal regulation. We appreciate the sponsor working with us over the interim to get this language right and for all the work she's put into the bill and request a favorable report. Thank you.
Chair, members of the committee, thank you for allowing me to testify today. My name is Matt Schwartz. I'm a policy analyst with Consumer Reports. Implemented in a few key ways, we support today's legislation. By far, the most important privacy protective feature of this legislation is its data minimization provisions. This bill would go a long way towards reining in the rampant over collection of data by tech companies by limiting the collection of personal data to that which is reasonably necessary to provide the service. And for sensitive data, it would create an even stricter standard, which would essentially ban third-party targeted advertising and sales of personal data based on our race, religious beliefs, health data, and data about children by default. These are the types of strict standards and privacy bills that privacy bills need to reach for in order to meaningfully protect consumers and change the business practices that have eroded our basic expectation of privacy in the internet age. For this reason, you're going to hear industry say that we should align with weaker laws that have already passed in other states. While some of those laws are better than the status quo, none of them set strong default protections. And instead, they mainly put the onus of privacy protection onto consumers themselves. You should reject that approach. At the same time, we do wish to mention a few recommendations that we think would improve the consumer protections in this bill. First, the drafters should broaden the opt-out rights to include all data sharing. We've suggested some language to close those loopholes in the current definitions in our written comments. We also believe that there's loopholes related to the concept of bona fide loyalty programs, which may allow businesses to unfairly discriminate against consumers that use their rights under this act. And finally, we suggest that the drafters include a private right of action so that businesses can be incentivized to comply. Thanks so much again for the opportunity to testify.
Thank you, Mr. Chairman, and members of the committee. Jamie Gregory here representing Airbnb, a company that was founded in San Francisco in 2008 and now does business worldwide. Airbnb takes its responsibility seriously to protect the personal identifying data of its hosts and consumers. Requirements currently are inconsistent on how and when information can and should be released. A firm, consistent standard will both provide guidance and protect consumer information. Additionally, it is imperative that when personal identifying data is requested by a government entity, that it is presented as a legitimate, compelling request. We are requesting a favorable with an amendment, and the amendment being a local governing body shall not require a controller or processor to disclose personal data of consumers unless pursuant to a subpoena or court order.
Delegate Harrison.
Thank you. I have a question regarding the HIPAA restrictions that were mentioned, the Graham Leach Blythe Act, and I guess one of the two of you, I'm not sure who will answer, but someone goes online and looks for a loan, I guess. Would they, under what it is that you're proposing, would they then possibly get ads from other loan agencies?
So I just wanted to clarify that I brought up the Graham Leach Blythe exemption because I was making the argument that insurers who are already required to comply with the strict privacy and safeguarding requirements in HIPAA should be included in that same exemption list. To your specific question, I don't unfortunately have the answer to that, and I'll be happy to follow up with you after the hearing.
I think that's important, specifically citing Delegate Love's example of the individual who went online to make an appointment and then started receiving ads. If we're talking about data privacy, or we're talking about privacy, online privacy, and we start talking about financial institutions, I think that it all falls in the same. So I would be interested to know if that, if an individual then would be prohibited from getting ads from other financial institutions.
I agree, Delegate, and I'll be happy to follow up after the hearing if that's all right with you.
Delegate Queen.
Thank you, Mr. Chairman. Some of my comments are similar to the other delegates. You're testifying with amendments, so I'm trying to understand, is there something different than what we see here? Because HIPAA is already listed as exempt here in the bill.
So may I, Mr. Chair? Delegate Queen, for the Bankers and the Property Casualty Insurers Association, the language that's in there for Graham Leach Blythe as written covers the entities, affiliates of the entities. We are also asking for the word data to be included in that clause. That is consistent with a number of other states who have adopted a comprehensive data privacy policy. I believe that's included in Tennessee which is what we've shared with some folks that we would support.
Okay, so we haven't seen that amendment then.
You have not seen that amendment, and we will be certain to get it to you.
Okay. That's my question. Thank you.
Sure.
For the gentleman from Airbnb, you guys just had a data breach of 1.2 million records in October, correct?
Actually, I'm not aware of that.
Google is, but I don't know if that's, I mean, I just Googled it and that's what came up. So just curious how this bill would impact if that took place, if the law were in effect. Can you please follow up?
I will.
Okay. Don't think I see anybody else. That concludes this panel and the favorable with amendments. Now we will turn to the unfavorables. Start with Andrew Kingman, Carl Zabo, Margaret Durkin, George Sewell, Kaylee Locklear. You can start when you come up, no particular order.
I'll go.
Yeah, you're.
Good afternoon, Mr. Vice Chair, honorable members of the committee. For the record, Kaylee Locklear here on behalf of the Maryland Retailers Alliance. We are in opposition to this bill. I submitted written testimony to you with numerous amendments I cannot cover in the amount of time that I have. The sponsors have them. I am going to circle back with her. She did accept some of them, but there's more work to do here. So I'm glad to review them if the committee wants to talk about them. I do want to focus my testimony on making clear that private right of action is not allowed. We believe there could be stronger language there. And most importantly, the loyalty rewards portion of the bill. I had all this written, but I have a better way to do this, I think now. So we're not asking for any sort of exemption in this bill. I want to make that clear. I realized over the years I haven't really said that in reference to this section. So first of all, we are required to disclose under this bill if we are going to sell data. The majority of retailers do not do this. This is page 22, line 17. We are subject to that. We are not trying to be exempt here. So then I'll move on to page 20. And Vice Chairman, this was what you were getting at earlier. Line 16, the bill says that you cannot charge different prices. The bill then goes on page 21 to say that it creates a loyalty exemption, and that's on line 27. But then we go to page 24 and there is a conflict between an opt-out signal and then the loyalty rewards program. So we do have a fix here, and I will share this with the sponsor. We believe if we just put on page 21 at the end of this prohibiting a controller from offering different prices portion of the bill, if we just insert that complies with subsection E and the disclosure, hopefully we can go ahead and close this chapter on loyalty rewards. So I'm glad to answer any questions the committee has. Thank you.
Jump in. Hi, good afternoon. My name is Andrew Kingman. I represent the State Privacy and Security Coalition. We're a multi-sector coalition. And I also have a background as a privacy compliance attorney. We're here today with optimism that we can continue working together to get this bill across the finish line. We've provided a list of our top priorities to the sponsors, to the Attorney General's office. And we're going to continue to work through the issues that we've identified and happy to get into that if necessary. Our priorities are focused really on two areas. The first are on provisions in this bill that don't appear in other states that would either create convenience issues for consumers or compliance issues for business. And then the other area that we're focusing on are provisions that are in all other state bills that do not appear in this bill. And again, we're working with the goal of getting this across the finish line. We understand this is a priority for Maryland. As someone who started coming to this committee when I had a full head of hair, I look forward to trying to get this across the finish line and happy to take any questions. Thank you.
Mr. Chairman, members of the committee, my name is Carl Zabo. I'm Vice President and General Counsel for NetChoice. I'm also an adjunct professor at George Mason Law School, where I teach internet privacy law. So you're actually hearing a common theme across here. I'm a lifetime Maryland resident. I went to Wild Lake High School. My kids go to public school here. Andy doesn't have any hair left. And we've been coming back
I have
and,
some hair.
okay, sorry, I will stipulate, Andy still has some hair left, thankfully. But we've been coming back time and time again to do this. And what you're not hearing from anyone on this panel is don't do a privacy law. Nobody up here is saying that. In fact, we're going state to state trying to enact privacy legislation where we actually face opposition from some of the groups that you heard previously, like EPIC or PIRG, claiming that it's weak or it's not enough. Well, essentially, they fundamentally do not believe any data collection ever. Businesses are inherently bad, so it's never going to be enough. We are here to reach a process that actually works for everyone. Connecticut works. Virginia works. Today, both those states, as weak as those laws are, they are 1,000,000 times stronger than the non-existent law we have here in the state of Maryland. We are working with the sponsor. If we can reach consensus, it's going to be a great win for all Marylanders, myself included, and Andy's hair. I will also note that I do actually agree with the AG. We should give the Attorney General the resources they need to enforce the law, not just this one, but all security, data breach, cybersecurity instances. And then finally, if you actually want to go well above and beyond Connecticut, go well above and beyond Virginia, you can do what Colorado does. And they include every data collector to be subject to this law. So two of the groups that you heard in support of the law are nonprofits. They can collect as much data as they want. They're not subject to our data breach laws. So if you actually want to go above and beyond, I would say cover every data collector. But let's get this done. Let's do the easy way and let's adopt these amendments that we're proposing.
Good afternoon, Vice Chair Crosby and members of the committee. My name is Margaret Durkin and I serve as the Mid-Atlantic Executive Director for TechNet. We're a technology trade association and we appreciate the time that both sponsors in the House and Senate have taken to include TechNet in the conversations early since the fall and often. I also want to thank Chairman Wilson for his thoughtful leadership on this issue. And similar to what other speakers have noted, we are here not to gut and defeat this bill, but to make it better and to focus on that interoperability among states. Areas that we will be focusing on are definitional alignment as well as enforcement. Specifically on the enforcement aspect, we appreciate the sponsors' desire to not include a PRA. That's something that is a priority for TechNet. However, we'd like to see that portion taken a step further to further clarify that nothing should be construed as a private right of action under this law or any other law. And we've been in contact with the Senate sponsor specifically on that issue. Happy to take any questions. Thank you.
Good afternoon, Mr. Chairman and members of the committee. My name is George Sewell and I'm here with the Security Industry Association. We represent companies providing a broad range of safety and security focused products and services in the US and throughout Maryland, including more than 40 companies headquartered here in our state. Among other sectors, our members also include the leading providers of biometric technologies available in the US. Privacy is important to the delivery and operation of security systems and services, and our members are committed to protecting personal data. While we are pleased to see the measure as introduced is similar to the emerging consumer data privacy standard common among the vast majority of states that have enacted such measures, we believe numerous changes are critical to bring it into full alignment that will support uniform and thorough compliance. Of these, we have submitted several key proposed adjustments to the House and Senate sponsors of the measure, none of which alter its intended effect. Firstly, ensuring the definition of biometric data is consistent with the current standard across existing state data privacy laws. Second, ensuring similar definitional alignment for various security and anti-fraud exceptions. Third, addition of explicit language ensuring exclusive Attorney General enforcement. And lastly, addition of a local preemption provision, which is also standard across the existing state data privacy laws. We support the overall goal of HB 567 in safeguarding personal data and information, and these key changes would address our concerns with HB 567. Thank you so much for your time.
Delegate Prusky.
Thank you, Mr. Chairman. I actually had a business reach out to me about this bill. And there was an article in August of 2023, which talked about the different states. And I believe it was Mr. Kingman. The person that sent it to me had a concern about the right for cure. And I know you mentioned other states. So Can you help me kind of understand that? Because I'm looking at this article and it has things related to the period. It also has what it's applicable to. I'm just, every state's different, but if you can kind of quickly summarize what exactly that.
What a right to cure is?
Correct.
Sure. So the right to cure is a provision that all other states in their privacy laws have had. At some point, California's is no longer in effect, but it gives the Attorney General the ability to simply send a letter instead of opening an investigation if there is a consumer complaint about a violation of the law. And it requires the business to act within a defined period of time, 30 days or 60 days, and provide assurances in writing that no such violation will happen again. And if they do that, then no enforcement action will be brought. So, many states have found that to be a very effective enforcement mechanism to weed out the bad actors from the good actors who are trying to comply with very complex requirements. So that's what I'd say about that.
Thank you.
Delegate Queen.
Thank you, Mr. Chairman. Thank you all for being here. Just want to get some clarity because, we've been working on this for a while and I assume we will work on this bill again this session. I believe everyone up there is signed up as unfavorable, but I hear these comments about these amendments and we want this strong bill for Maryland and that we could look at these states, but yet I have no written amendments. So I guess I want to ask a clear question because, we've been here a long time and I don't want you to have no hair when we finish.
Sorry, I did that.
I know.
But are you here, and this is a yes or no question, I'll use the term someone else used on your panel. Are you here to help us pass a strong bill or are you here to gut this bill? Yes or no, which one? Each of you can answer.
We're here to help get this over the finish line.
A strong bill.
Yes.
Yes, a strong bill.
Next,
A strong bill that works.
a strong bill or gut the bill. Yes or no?
The goal is to get the right bill.
Next,
Yes, a strong bill.
next.
Yes, and I submitted amendments too.
Thank you.
Delegate Chi.
Thank you, Mr. Chair. I should have asked this question during the first panel. It says clarifying question, but probably at this point, it's more directed toward, I forgot your name, the gentleman in the middle, who was advocating for a broader applicability of this bill. So it sounds like from what you stated, we should have broadened the scope to also apply to anybody that collects data, not just the companies. Correct? Can you elaborate on that? Are you saying we are exempting nonprofits or local governments? Because, from an earlier statement that I read from, I think, the Treasurer's Office, they said it should apply to all of the state instrumentalities. But how about the rest of them? So I would like to hear your statement on that.
Yeah, thanks for the question. It's a very astute one, mostly because I agree with the presumption. So if you actually look at the European privacy law today, it covers every data collector. The purpose is to protect every single American, regardless of tax status. So, for example, I am a 501c6. So I am a for-profit corporation. 501c3s are a nonprofit corporation. They are exempted from this law. They can collect, use, lose, abuse data with impunity. The same is true for our data breach laws today. There is one state in this country that I know of, the state of Colorado, that actually has the Connecticut, Virginia approach, and they did one teeny tiny tweak. They said, you know what? We think that this should apply to everyone. It's very easy to support a bill or a piece of legislation that has no impact on you. If you're not subject to it, it's very easy to support. Once the table gets turned and you suddenly realize the cost of compliance, the difficulty, the challenges, you then begin to hedge your bets. You start saying, wait, maybe we shouldn't do this. Maybe this is too far. And that's actually what we started to see in the state of Colorado. So I would suggest that this legislation apply to every data collector, just like it does in GDPR, or just like it does in Europe, just like it does in the state of Colorado, because you should not be exempt from these protections, and my data should not be exempt from these protections regardless of your tax status.
I agree in principle, it should broaden the scope, but I just want to make sure you are accurate in what you stated, because I'm trying to find where it says that nonprofits are exempt in the bill.
In the definition of who covered entity, it lists out several. It says, and basically they are for-profit corporations. So if you go into the definition of covered entity, the next line is that does something for profit.
All right, thank you. I'll look for it.
We'll go Delegate Blythe, Delegate Weibel, Delegate Harrison. Delegate Blythe.
Thank you, Mr. Chairman. And sorry that I missed the party. This looks like it's been a fun testimony so far. I got 3 quick points to make, and then I'll yield my time to my colleagues. First, I just want to make sure we're clear. There is no PRA in this bill, because from the opposing testimony, it sounds like you're saying that there was one and that it needs to be clarified a little bit more. Can you take some time, and this could be it for anyone who's on the panel, to talk to me about what you mean by clarifying it more when we don't have it currently existing in the bill right now?
Yeah, sure. So first of all, we very much appreciate the sponsor's intent to not have a PRA in the bill, something that's been, a holdup for the business community in the past, and we really appreciate where this bill is starting from. All other states that have passed a comprehensive privacy framework make it clear that the Attorney General has exclusive authority to enforce the provisions of this act, and also that there is nothing in the act would be construed to create a private right of action under this act or under any other law. So the concern there is that, for example, Maryland's data breach notification law has a private right of action. So the goal is to have language, and again, that exists in all other states, that makes it clear that someone bringing a private right of action under the data breach law could not claim that there was also injury sustained under this law as well. So again, that's just that falls into our priority of ensuring that there is language that is in all other bills that's in this one.
Thank you. My second point is for Carl from Net Choice. Carl, right? I think we're gonna have to talk a little bit offline, because I'm a bit confused with your testimony, right? In one regard, we're talking about this needs to go further, but you're here unopposed. And we're also not trying to have the piecemeal approach to privacy at the same time. So I'm a bit confused with your testimony, but I just wanted to put that out there that I think we should talk offline, because I want to understand a little bit more about what you were talking about in regard to moving in a holistic direction on data privacy here. The third piece, again, could be for anyone on this panel, but my colleague from Anne Arundel County just talked about the right to cure. I don't believe, I'm not a lawyer, I just play one here in this committee, but we talked about the right to cure. I don't think that exists in Maryland consumer protection law now. And it seems like there's a desire for businesses, understandably, to have that. Talk to me about the precedent that would set, not just for your industries, but we're talking about Maryland businesses holistically as well. And if folks don't have the answer to that, I'm happy to chat offline.
I would just say, as I said, I think other states have found, other state enforcement authorities have found it to be a useful tool to encourage compliance. And it also is a great way for the consumer to obtain redress about their violation in a very defined period of time. So instead of litigation or investigation that goes on for a long time, they're getting their problem fixed. They submit a complaint to the Attorney General, and within 60 days or 30 days, they have redress for if there was a violation.
Right. I understand it in concept and theory. I guess my concern is that I believe that those other states have it in statute, in consumer protection law as is now, and Maryland does not. We can talk again. Am I correct in that, Council and Mr. Chair?
Yeah.
Okay. So I think that's where at least my personal concern comes from as we talk about that. obviously this will be a conversation that the committee has as we move forward on
Yeah,
this
so
piece of legislation, but just wanted to flag that for the record.
Okay, I appreciate that. I don't believe that it existed in other state laws before the privacy frameworks came in.
That's what I was trying to get at. Thank you.
Yeah, I don't believe that it did.
Okay, I appreciate that. Thank you.
We'll come back to that in a second. Delegate Weibel.
Thank you, Mr. Chairman. The gentleman in the center, I wasn't clear. Were you speaking, your professor was at Georgetown?
George Mason.
George Mason. All right. Are you representing them, representing yourself, or?
No, I'm representing Net Choice.
Net Choice. Okay. And I know you talked about the definition of covered entity. Are you referring to M, which just says has the meaning stated in HIPAA, or is there somewhere else where it's?
No, it's further up. I'm happy to point it out offline, and I think it's worth making clear the scope.
Okay, did you provide written testimony? Because you talked about a couple amendments.
No, I did not provide written testimony. I would actually defer to my colleague. So Andy Kingman over here from the State Privacy Security Coalition is one of the preeminent experts on this issue. And so I would defer to any discussion of amendments to him.
Okay. And then finally, you talked about states that you thought got it right. Have you actually done comparisons of this, rather than reinventing the wheel? Have you done actual comparisons with this bill to those states? And are you able to provide that analysis?
100%. In fact, that's what we're trying to do, is to bring everything into compliance with Maryland surrounding states. So for example, my brother chose to live in Virginia. He makes bad decisions all the time. So we're trying to make sure that when I go visit him, the privacy protections that I enjoy remain the same as we go across state lines. But similarly, we're trying to bring Maryland into compliance with many of the other states around the country. But Mr. Kingman, I believe, does have a diff of Maryland's proposed legislation and the other bills or laws.
Compared to the others, you can provide that.
Sure.
Okay.
Sorry, Andy, to put you on the spot.
Thank you.
Thank you. Yeah, I was going to mention that the definition of covered entity has the same meaning as in HIPAA, and that's what's in the that we see just in looking at it real closely. But my question was to the last gentleman who spoke. Now, I'm sorry, I forgot your name, but you were speaking of the biometric data, and I'm not quite sure if I totally followed you. Can you just simply say what it is that you want or don't want, or yeah, I just kind of didn't follow that.
Yeah, absolutely. So the definition of biometric data in the actual bill, we want to change to be aligned with all the other 14 state consumer privacy laws and how they define it. And it's been enacted that way in other states since 2017. And it's critical to ensure that the definition doesn't mistakenly cover non-biometric information.
Okay, thank you.
Yep, just to touch on the covered entity, I mean, as I read this, sir, and we're up here all talking, like, I don't think nonprofits are exempt. So you might want to take another look at that.
Happy to.
So I don't think that based on that, any of the testimony that says they were exempt is even remotely true. Second, on right to cure, just kind of curious, right? On a data breach, how do you plan to cure something when it's already been breached? Like, I'm just curious how that plays out practically.
So data breaches would be covered under the state data breach notification, not this bill. This bill does require particular administrative controls, but the data breach statute doesn't have a right to cure, and it does have a PRA for actual damages.
Okay, but under this bill, let's just say there's a violation. How do you plan to cure that? How would that work?
So again, I'm sorry, this bill doesn't cover data breaches. So that would be governed by a different statute.
Okay, but let's say there was a violation under this bill. How do you plan to cure that? Somebody sells my data when they're in violation of this. How do you cure that?
Sure.
That's silly. That doesn't make sense to me.
Yeah, I mean, I think it would depend on the circumstances of the sale and
well, that's what I'm asking you. Give me a circumstance.
it could be a contractual requirement by the Attorney General in the enforcement action to delete if a cure wasn't possible. So that could be an enforcement remedy there to delete the information that was sold or require the entity to whom it was sold to delete that information permanently.
And
Okay, but that would be somebody that is compliant or like purchased it out. Okay. I don't necessarily think that that's going to work out practically, but all right. You got something, Chris? Yep, Delegate Adams.
I'll follow up on that. So
Sure.
if you've got a right to cure, that's in business regulation, that's like coming to compliance. Now, the question I think that he's raising that's a legitimate one is what happens if you have like repeat violations, if there's a pattern of behavior,
Sure.
Because I think that's where I would get frustrated and the committee probably.
Yeah.
I mean, I get the compliance part if there's a one-time, first time. What do you do with the bad actors? That have
So
multiple-
the language that we would propose would require an express written statement that no such further violations would occur.
Or else, I mean, that's where he was.
Well, it's an express written statement to the Attorney General that no such violations will occur. So if it does occur, then you are no longer afforded the right to cure for that violation. We also, the language would provide the right to cure at the Attorney General's discretion. So if they do not believe that a cure is possible, then they would not necessarily have to offer one. So that would be the other way to address the concerns that the committee members brought up here.
Yeah.
And just one small
Sure.
point
Go ahead.
to address the chair's question previously. If you fail to cure, you're still on the hook. It is a right to cure. It's not an exemption from violation. So if you fail to provide the necessary remedy within the time frame provided, you are still on the hook. So in the example that was provided, if I'm unable to get that data back, to make sure it's deleted, to annihilate it, to the satisfaction of the Attorney General, no remedy is provided to me.
Thank you, Vice Chair.
Delegate Howard.
Something like, so somebody collects my data and sells it, they're in violation, they notify me that they've sold my data and what remedy they're going to do that's going to take place as far as my data, like protecting that data moving forward. Is that like credit monitoring, or walk me through this a little bit better?
Yeah, so I think the way that a consumer would probably be aware that that the business did not comply with their request is that if they opted out of the sale of their data and targeted advertising, but we're still, seeing targeted advertising come up.
But what if
that they'd have a sense
that didn't happen and then they were in violation, let's say from the state? So would it be incumbent upon the business to notify people, hey, we were in violation based on the AG's interpretation of the law, and ergo?
Sorry, I'm not sure I understand. Can you just repeat the first part of that?
So what if they were in violation and it was interpreted by, let's say, the AG's office found that company in violation of the.
Sure.
Right. So they didn't opt out. They didn't have, there was no change in their user interface or platform, whatever.
Yeah.
There was no change.
How would the consumer be aware?
Yeah. How would the consumer be?
I think the Attorney General would have to respond to the consumer to say, we've addressed your complaint or we're following up on your complaint.
To that consumer.
That's right, because the consumer would file a complaint, right?
Mm-hmm. So I don't want to belabor this, but so what if it's not a consumer complaint? What if it's just through normal course of investigation, or that data, that it's found out that they're not within the.
I think that would be at the discretion of the Attorney General as to how to announce that or enforce that.
Okay.
The Connecticut Attorney General's office just put out a report that they were required by statute to put out on kind of the first year, I think it is, of enforcement and what.
So that's kind of the curing you're talking about. Is that what
The curing is an opportunity if a consumer files a complaint
Right.
with the Attorney General. The
Okay.
cure period is a 30-day, let's call it, or 60-day opportunity for the business to fix that violation.
Okay.
So whether
So regardless of who files the complaint, the curing portion would be the remedy, the remediation.
yes, if the Attorney General deemed that that was possible,
Mhm.
and if the business actually did that, and if they didn't, then they would be in violation of the law.
Okay.
So it's, it's served in other states. So in California, they found that 75% of the companies that they provided cure notices to came into compliance with the act and fixed the violation. The other 25% were either at the time of the report in the process of fixing that or had ignored it, and they were opening up investigations on those companies for violations. So in that way, it was effectively a gatekeeper to sort of separate the companies who said, okay, our privacy policy wasn't in compliance in a way that, was a good faith violation. We'll fix that now. Versus the companies that said, well, we're not going to bother complying, or we're not going to take compliance seriously. They weren't able to fix the violation and had investigations opened.
Okay. Thank you very much.
Sure.
All right, seeing no further questions, I would just urge this panel to get your amendments to the sponsor and work with a sponsor. That concludes this panel. We have 3 more unfavorables and then 1 virtual, I believe. Hannah Gargiola, Andrew Griffin, Rebecca Schneider.
Good afternoon, Mr. Chairman, Mr. Vice Chairman, members of the committee. For the record, Andrew Griffin here on behalf of the Maryland Chamber of Commerce, in very respectful opposition to the bill. I am not going to belabor too many of the points you've heard. I think first I want to recognize the work that's been done by the bill sponsor, the chair of the committee, and others. The bill we have before us is drastically different than the bill we have seen the last 4 sessions, and I think that shows the willingness to work with the concerns, and that's fantastic. And obviously, our major concern had always been the private right of action. In our view, that is addressed. I think I want to press on the fact that this is not the business concern with this bill is not of one of just certain companies. I hear about it from businesses of all sizes. I hear about it from businesses across different industries. And you've heard from some today. The nonprofit discussion earlier, I received a frantic call yesterday from nonprofits that they are in fact included in the bill. They don't want to be included in the bill. And so what I would offer to a question asked earlier is if I can serve as a central point for amendments to the committee, because I have all the concerns of everyone you've heard from. Please, I'm happy to serve in that role and be that to the group. So you have my written comments of some of the higher level issues, most of it definitions, timeline for compliance, things like that. But otherwise, I appreciate your time and happy to continue the conversation. Thank you.
Thank you very much, Mr. Vice Chair, members of the committee. Hannah Gargiola, opposed to House Bill 567, here today representing CTIA, who is the wireless communication industry. You have their written testimony in your packet. So as currently drafted, CTIA opposes House Bill 567. CTIA members remain concerned about online privacy and support measures to empower consumers with the right to control their own data. However, CTIA believes that this issue should be addressed at the federal level. The state-by-state framework for regulation is creating a burdensome patchwork of different laws across the country, and therefore CTIA is supporting a uniform national approach to consumer privacy. Deviating from clearly defined definitions, obligations, and privacy protections could have serious consequences for consumers, innovation, and competition. We believe that this state-by-state approach will complicate the federal efforts and impose compliance challenges and confuse consumers. But in the absence of federal action, CTIA does believe that the approach taken by this bill is good. However, uniformity is needed as definitions are different from state to state. One additional concern that's been talked about a few times today is the bill does not include a right to cure, which is also included in Colorado's law, Connecticut's law, Virginia, and Utah. In conclusion, there's concern over the state-by-state approach. There's concern over the differing definitions, and there's concern over the lack of a right to cure provision. Thank you.
Thank you. Vice Chair, members of the committee, I'm Rebecca Snyder, the Executive Director of the Maryland, Delaware, DC Press Association. I think we're here unfavorable because I didn't get an opportunity to talk to the sponsor until after the filing deadline. However, Delegate Love and I have been talking about various ways to address the concerns the Press Association sees. The geofencing issue and is certainly something that we have concern about. And have understood from the sponsor that that is more of a technical amendment. And where we still have concern right now is this data collection limitations. I think, this bill sits in context with Connecticut's law. There's 14 online privacy laws and more cropping up, I'm sure. And as Hannah said, there is a patchwork and probably no federal solution in sight. But on the data collection limitations, we feel like this bill goes a little bit too far in terms of looking at specific products or services requested by the consumer. So what we want to make sure is that advertising is always going to be a secondary product to anything that any business has. And so we want to make sure, although consumers certainly have a right to their own data, we want to make sure that advertisers and businesses have the ability, even with guardrails, to advertise. And so I hope that we can continue to work with the sponsor on working through those concerns. And then the enforcement, we suggest having the Attorney General giving exclusive authority to the Attorney General to enforce the violations. So we currently are unfavorable and working towards being something else. So in the interest of continuous revelation, I ask you to consider our amendments to the bill. Thank you.
I've never heard that before. Delegate Adams.
I mean, I sort of liked it. It sounded good. So Hannah, you brought up something that I was in listening mode on this bill here for the most part, because we've had it a number of years, and the private right of action, I'm halfway sold. So let me just say to you, the last part you were mentioning regarding multi-state, I was listening to Delegate Arendt's talk about, hey, show me Delaware, which is the one that this bill appears to be modeled after. But it does beg the question, I guess, and I'd be curious maybe further if you would, maybe Andrew. I mean, at some point, we're going to have 50 states are going to have some version of this bill, and it does beg the federal government to sort of make uniform this for just compliance purposes, I would think. But as we're sitting here today, your testimony is you would prefer to see that happening. And I don't know that I have any faith in seeing that happening at the federal level. That's the rub, isn't it?
Yeah, I agree with you.
Yeah. Okay.
Yes, we would agree with that.
I mean, but I don't know. So thank you.
I think a bill got out of committee last year on the federal level, but it hasn't been brought up.
It did. And careful, it has a PRA.
Thank you.
Thank you.
I hope I didn't miss anybody else. Okay, seeing no further questions, that concludes this panel, and we have one unfavorable virtual, Kara Bonder. I apologize, ma'am. Go ahead when ready.
No, I think you got it right. Thank you very much, Mr. Vice Chair and members of the House Economic Matters Committee. Thank you for the opportunity to speak today. My name is Kara Bonder, and I'm State Policy Director at the Computer and Communications Industry Association, also known as CCIA. CCIA is an international not-for-profit trade association representing small, medium, and large communications and technology firms. And for over 50 years, CCIA has promoted open markets, open systems, and open networks. CCIA appreciates the significant effort that lawmakers have undertaken to strike the appropriate balance for meaningful protections while preserving benefits consumers receive and the ability for innovation to thrive. While we appreciate the sponsor's work on this bill, HB 557 still would diverge from existing frameworks in several key ways. CCIA has submitted full written comments, but I'd like to take this time to highlight several points which echoes those voiced by those before me today. Key definitions in HB 567 are likely to prompt significant statutory interpretation and compliance difficulties, even for businesses with existing familiarity with other U.S. state laws. Specifically, CCIA recommends attention to the following terms to align definitions such as biometric data, consumer health data, and targeted advertising. We also suggest aligning the definition of geofence. And finally, we suggest clarifying that the definition of sensitive data will encompass the personal data of a known child, as this would be consistent with the actual knowledge standard under COPPA. Finally, we request clarification that the bill would not allow for a private right of action. We again appreciate the significant work that has been put into this bill and look forward to getting to a place of support and getting this across the finish line. Thank you for your time. I welcome any questions.
Thank you very much, ma'am. Seeing no questions, I believe that concludes your testimony in this bill hearing. We're going to move on to, I think, Delegate Jazz Lewis. Is that it? No. Is Delegate Lewis here? You just popped in. Good boy. All right, well, we'll go to Delegate Solomon, House Bill 603. And please bring your panel up, sir. And as you're well aware, while we're sponsoring this bill together, I'm not going to steal your shine. You've done a lot of work, so I want to, let you go ahead and take the lead, brother.
If anything, I would bask in your glow. And I'm just going to call up my panel, Marissa Shea, Andrew Liu, and Liz Park. Thank you. Just want to make sure I'm in the right spot. Yeah, that's cool. Good afternoon, colleagues. For the record, Delegate Jared Solomon here presenting House Bill 603, the Maryland Kids Code. And I want to just start off again by thanking Chair Wilson, who's been an incredible partner on this bill over the past year or so that we've been working together. It's not too often you get to work with the chair of ECM on a bill like this. And I just want to recognize him for his incredible work in protecting kids. And that's really what this bill is fundamentally about. I also want to thank the Speaker and the Senate President. We don't usually do that, but this bill has also been included in the presiding officer's data protection and consumer protection package. And again, we know how important protecting kids are to both the presiding officers. So I want to make sure I got a chance to recognize them. And I also want to start off by saying this is a bill actually that the committee passed and the House passed last year, pretty overwhelmingly with 110 bipartisan votes in our full chamber. So I'm not going to go too much into the details because again, the bill is pretty similar to the one last year. I will mention some of the changes and amendments that we've made. But I wanted to just start off by sort of saying what's changed since we had this hearing about a year ago. And there's actually been quite a bit, I think, in just the general way that society has looked at this issue. So today versus last year, I think folks were still sort of trying to wrap their heads around it. This is an issue that people kind of knew of, but didn't really know viscerally. Well, since that hearing last year, we've had 40 states attorney generals bring suits against Meta and other social media companies, including Attorney General Brown. And you're going to hear from folks from his office. And I know he was in here earlier, but had to leave. But we've been working with him and his team. There are two that I really wanted to point you to. The New Mexico Attorney General's filing. They actually had a group of their attorneys pose as children and parents on these platforms. And literally what they discovered was they were allowed to traffic their children. Within hours and days of setting up these accounts, they were being solicited for sex, really heinous things. If you're interested, I would take a look at it. The Vermont filing, which was part of Attorney General Brown's filing, showed that Meta had actually hired scientists who knew all about childhood brain development, and their products were specifically designed based on the way that a young person's brains developed to make these products as addictive as possible, to make sure that our young people stay on these platforms as long as possible, because the longer they stay on it, the more money they make. And then closer to home, we've actually had 10 school systems in this state sign on to a class action lawsuit against social media companies, specifically social media. And those are systems as diverse as Baltimore City, Prince George's County, Montgomery, to Harford County, Cecil County. So, every corner of the state, school systems have recognized the incredible harm that unfettered sort of profit motive from big tech is doing towards our young people. And obviously they're the ones that have to pick up the pieces and deal with it. And that was really the whole genesis for us getting involved in this issue was, we all know the mental health crisis that we see daily with our young people. I'm a former high school teacher, spent a lot of time working with high school students and educators in my community, and you hear it every single day. We've invested millions of dollars as a body in fixing the issue. And to me and to Chair Wilson, this was about how do we get to the issue before we have to remediate it, right? How do we get to the core and the root problems behind it? So I'll go through just a couple of the amendments that we made to the bill, again, that make it different from last year. So we did a little bit more to define the best interest of the child and create sort of a minimum duty of care. And there's a lot more detail in my testimony, so I'm not going to go into it all. We changed the likely to access to make it a little bit more reasonable because we wanted to make sure that obviously if you're, the difference between an entity like a YouTube or a social media entity versus, like a Nationwide Auto Parts or something, where even if both entities had 2% of their users as children, obviously 2% to YouTube is, potentially hundreds of millions. But 2% to, Napa Auto Parts is like probably 20,000 or something. And you don't necessarily have to do the same level of analysis or, thought on how you design your products if that standard is different. We also changed the data protection impact assessment, which is, again, how companies are supposed to kind of balance out profit motive on one hand, potential harms to kids, and think through the way that they're designing their products. We made some changes there. And we made it clear that this is not about pinpointing exactly what age a child is. There was a lot of discussion last year about age estimation, and we moved it to assurance, again, based on the risk of potential harm. I'm not going to go into greater detail on this as well, but I think most of you are probably aware this is modeled off of a bill in California. That bill was enjoined actually by a federal court. It's working its way through federal jurisdiction. The one thing I will say is we don't obviously shy away from a fight in this state. We have made tremendous changes working with constitutional law experts, making sure that our bill passed muster, as well as working with the AG. And so happy to go into greater detail on that as well. This bill is a proven model. It's based off of law that's been on the books in the United Kingdom for a number of years now. And it's the same type of core principles. And actually, a lot of the companies who their associations, and I think it's really clear if it wasn't from the previous bill, when you hear from these associations, they're not independent think tanks, they're not independent policy organizations. They are funded by some of the largest tech companies in the world. And so they often bring these associations to bear because they don't want to be seen with their fingerprints on opposition. I will say a number of them have been really great actors and partners in this. Google, I know, is gonna come to the table informationally, and we've been working with them. But I just want to make it clear that those groups are not organic. They are, very specifically funded by certain entities. But there were a couple of folks who testified before the U.S. Senate Judiciary Committee that you may have seen the headlines a couple of weeks ago. And so TikTok actually said they strongly and enthusiastically support this kind of child safety law. Again, Google made comments saying good legislative models like those based on age-appropriate design principles can help hold companies responsible for promoting safety and privacy while enabling access to the richer experiences that we know are really sort of the positives of the internet. The one piece that I did really want to sort of address head on, because it's starting to come around. So there is a federal bill called the Kids Online Safety Act, KOSA. These bills are not the same by any stretch. And again, I'm not going to go into detail on that. That's in my written remarks. But if there are questions, we're happy to take those or follow up after the hearing on that. But they are very separate bills. They are based on different sort of frameworks. There's a lot of conversation, obviously, on the last bill. We'd love for there to be a national framework. Congress, not the most effective body these days. So in the absence of Congress taking action at the federal level, states can really be the leader. And we've shown that in a number of ways. But there has been this sort of message thrown around by some folks that, we are somehow scrubbing LGBTQ youth off the internet because there are some provisions in the Kids Online Safety Act that may still need to be worked out. That is not our bill in any stretch. Our bill is not a content bill. And I want to reiterate that. It is not about the content that is on the internet. It is about what a site does with the data that they accumulate and the things that they're sort of pushing on you that you might not have clicked on otherwise. So if you are a young person and you want to go online and you want to look for anything, you still have that right. It is what companies do after you've done that search with your data, whether it's selling it, whether it's trying to manipulate you based on your search. It is all about the back end that they do with the data. So that was also one of the big changes. We made sure that content is scrubbed completely from this bill. It is not about the content on the internet. It is about what companies are doing with the data that they are collecting from you after you have gone onto the internet. And this bill was designed with young people, includes anti-discrimination protection language. And we are going to go back and make sure that we have every belt and suspender to make sure that the anti-discrimination language is clear enough. But if you hear that from the opposition, if you see that in messages, that is not our bill. The last piece that I just wanted to touch on is, again, this bill is really centered on youth and working with educators. And so I did just want to read a quote. This is from Principal Hornback from Hampstead Hill Academy, and he was at a press conference with AG Brown announcing the lawsuit. And he said, social media hijacks normal, healthy thinking. It sucks up so much time and keeps the user wanting more and more. It's not an overstatement to say it can steal big chunks of a childhood. The urge to check your phone is stronger than any consequences we have at school. This is a 20-year award-winning principal in Baltimore City who's been, their school has been a real leader on safe use of the internet from our students. And so with that, happy to take questions. Again, would urge a favorable report, just like we did last year. This is a way for Maryland to continue to be a leader. Thank you, Mr. Chair, again, for your partnership on this bill, and thank you all for your attention to this.
All right, I guess I will start this. So good afternoon, Chairman and members of the Economic Matters Committee. My name is Andrew Lear. I am a high school junior residing in Southern Maryland, and I am here in full support of the Maryland Kids Code. As today marks almost a year following my testimony for the same bill last year, it remains imperative to the needs of Maryland youth. My sentiments last year, including both the personal and universal disparity perpetuated by media pressures, coupled with widespread manipulation and targeting tactics by online advertisements. And as I recollect the monotonous reminders of my adolescence and online experiences, I wish that there had been change. Change in the form of higher privacy settings by default, veering me away from the heinousness of cruel people, tied with my blissful ignorance when I was unable to appreciate the sweeping impacts that social media can have on my life even prior to having any of the applications. And now it is no longer a yearn or merely a suggestion for legislative progress, but a necessity and a plea for change. Because oftentimes the root of generational insecurity is in the hands of algorithmic mechanisms, furthering the already prevalent anxieties of simply learning what it means to be human, which online is something that many people forget, that we are all simply human. No longer making this a game of solely technological restriction, but protection and a demand for people to see the human within the inhumane. And today we are given two choices: to protect and to sanctify the minds of youth, or to spiral them into the ever-growing endless loop of manipulation and systematic coercion online. And I cannot pretend as though it is not happening to me, to my peers, to the kids down the street that have barely hit double digits. Anyone can face it. It is all around us, and we continue to let it happen all the way to a global scale. And if this is a global issue, what is stopping us from initiating tangible change on a state level when we are given the opportunity to do so right now? And today, I have to ask you, what will your choice be? Thank you so much for your time.
Good afternoon, Chair and committee members. I'm Marissa Shea here today on behalf of Five Rights US, a project in cooperation between Reset Tech and Five Rights Foundation. I'm also a St. Mary East County resident. The current digital ecosystem did not happen by chance. It is the result of big tech's intentional choices. Notifications, endless scroll, autoplay, snap streaks, likes, screen refreshing, all of these are business decisions made by companies looking to maximize consumer use and attention. The result is online experiences that fixate, intentionally keeping children locked into their screens and devices. These types of data practices and design choices have been incredibly lucrative for these companies, but they are not the only way. In the letter submitted to this committee, different industry representatives reported that their tech company members are already making changes to raise standards for teen safety and privacy. This shouldn't be surprising since many of these large companies are already complying with a similar design code in Ireland and the UK. These entities will say that that's different, that the UK and Ireland don't have the First Amendment. But the First Amendment does not guarantee you a captive audience. It doesn't protect unlimited data collection or consumer manipulation through database profiling, dark patterns, and other design features that actually lessen an individual's ability to choose the information they interact with. What the First Amendment protects, content and speech, isn't regulated by this bill. In HB 603, the only reference to content is language that specifies children must remain able to actively search for and seek out specific information. Rather than limiting what kids can see, the data privacy protections and design requirements of the Kids Code should actually diversify the information seen by children and teens, because companies will no longer be pigeonholing kids' interests and recommendations through manipulative design. At its core, HB 603 is simple consumer protection. In short, this is a reasonable, vetted bill that walks the line between online privacy and safety in a manner that will actually benefit kids and keep the internet available to all. Thank you for your consideration. I'm available to answer any questions.
I thank you, Chair, and the committee for allowing me to speak. Liz Park, representing the Maryland Association of Youth Service Bureaus. We provide prevention and intervention services, including mental health services to youth and their families. And many of the families that we work with face this issue daily, how to help their children navigate the internet, how to help their children navigate the online world that they're exposed to. We work with kids who are getting bullied online, kids who have been pursued through their gaming devices, perhaps they're online playing on their Xbox. They're contacted by adults who then pursue them. And we work with adolescents who you've heard about who really struggle to put their phone down. I can tell you many sessions I've had with families where that is the whole discussion for an hour of how to help an adolescent manage their phone, because it is compelling. There's always one more thing to do, one more thing to look at. They feel left out if they're not part of that. And that is how they connect with one another, is online. We have a whole new generation who communicates through text, including my children, who prefer I text them rather than call them. So we have to help these kids understand how to navigate this world, but parents need the help. They need the assistance of how to protect their children online and how to help them deal with the anxiety, the depression, the suicidal ideation, the self-harm that comes when they're in distress because of what they've encountered online or because of how they can't feel safe in putting their phone down. The example that came to me, I was somebody born in the 1960s, and when I was born, there was no car safety seats. In fact, you could buy a playpen to put in your car to put your baby in so the baby could crawl around in the back seat while you drove. We would never think of not putting our children in child safety seats today. This law is the child safety seat for the internet, where parents can know that their child is protected and has the protections they need. So thank you, and I ask a favorable view of this bill.
I believe is that everyone correct? Yep. Okay, I just want to say again, thank you, Jared. I know this was a lot of hard work. I think obviously you've done an amazing job. You're much more kind and peaceful to the opposition than I am. So clearly nobody talked to me. They all went to you. So I'm glad for that. Again, I appreciate what you're doing here, and obviously, you know, without being too slanted, since my name's on the bill, I definitely see the importance of the bill. And Andrew, you did a phenomenal job. You use a lot of big SAT words. It's been a long while since someone took the SAT, brother. So a few people here on their phones trying to figure out what you said, but no, you did a great job.
Dictionary came in handy for the past couple of years.
I could see, but no, it was a great job, guys. Thank you very much for your presentation. We believe we have one question, Adrian.
Thank you, Mr. Chair. Thank you, Delegate Solomon, for your leadership on this issue, and to you, Mr. Chair, as well. Really quick, as I'm reading through the testimony, one of the things that seems to be a common theme is the unconstitutionality of this bill and a reference to the 2021 California law that kind of attempts to do the same thing. It sounds like over the interim, you've made some tremendous progress. Can you talk to the committee a little bit about the work that you've done and why you believe, as I think most of us believe with all of our bills, that this is not unconstitutional?
Yeah, thank you, Delegate. I'm going to touch on a couple of things, and Marissa's the lawyer up here, so then I'll pass it on to her. So one of the things we did last year, actually, as we were working on the bill, was we worked with our own Attorney General, and we got an opinion, making sure that we felt like we were on solid constitutional ground. You know, whatever the Ninth Circuit chooses to do, and that is still winding its way through the court, that actually would not bind Maryland. You know, obviously, jurisdictional issues, unless it's the Supreme Court, are held to just those districts. But the amicus briefs that have been filed, including one from Attorney General Brown, includes the American Academy of Pediatrics, the American Psychological Association, the Federal Trade Commission, and then a bipartisan group of 21 state attorneys general. So, I mean, this is not something we just kind of slapped together. And clearly we think we're on pretty solid legal ground, and so do a lot of other folks. But Marissa, do you want to talk about maybe some of the specific changes?
Thank you. So in terms of specific changes, I think what we really were trying to address in the updated version of this code is the sort of raised ambiguity that was called out through the California court. We, added, I think, a definition for best interest of children that, really tries to provide clearer guidance that puts up better guardrails looking back at our, tort law concepts that have shown some success and been sort of, allowed to move forward in the law, the school district lawsuits against tech companies. So we think this is sort of tracking more with American jurisprudence and, a positive change from what was introduced last year. We've also added a reasonableness standard throughout the code. Again, that's, legal terms of art that will allow decision makers the ability to weigh reasonableness when making decisions around likely to access and other aspects of the code. We've also, I think sort of streamlined some of the data protection impact assessment requirements. I, want to just call out that that is a regulatory sort of framework and process that's used in a lot of other industries. So even though, there's some contention from those with favorable opinions of this bill that that's not a regulatory framework that should be upheld, that it infringes on speech, we see it on all these other areas from, other product safeties, from the food industry, from clean water. So I think, this is a model that we also see across other states' comprehensive privacy bills like Connecticut, which many of those opponents sort of raised as being in favor of in regard to Delegate Love's bill. So, this is definitely an area of law that's still being worked out through the courts, but I think, we don't want to make Maryland's children wait while that's occurring.
Seth?
You talk, just back up and walk me through it just real quick. You talked about reasonableness and the standard of reasonability for children's safety. I absolutely agree with that, but I'm just wondering who makes that. Is that out and is that even outlined in who would make those?
If I may, through the chair. So where reasonableness first shows up in the amended code is in our likely to access determination. So the initial wearers of that question would be the sort of companies when they're making a determination if they fall within scope of the code. Then if the Attorney General would be responsible for enforcing this act for Maryland. If the Attorney General were to bring forward a case, it's required that they review sort of and request the DPIA or the data privacy impact assessment information. They would also, I think look to the reasonableness aspect as it's sort of covered throughout the code and use that in their review of what's been offered. And then obviously the court would be sort of the ultimate decision maker if, charges were brought forward against companies per the code. They, would see and make sort of that reasonable person determination as, it would depend sort of what the specific question was in response to. But, in regards to, I think the main question of reasonably likely to access, so if they fall within scope, and then also throughout different considerations that they'd be making in regards to their data practices and design practices.
Can you reach out to my office? Because I definitely have some more questions for you.
I was going to say, and Delegate Howard, the one thing I wanted to add is, and there was a long conversation about it in the previous bill, but our bill does include a right to cure. And the whole point is, again, we talked a lot about this last year. This bill is not meant to be punitive. We're not out to get these companies right. And designing these products is obviously, it's not a perfect science. And so we want companies to think through as they're designing, and we've talked to a lot of technologists that sort of the binary approach of harm versus profit actually helps them as they design their products. And so if there was something unforeseen, we give companies a 90-day right to cure, as long as they've done the impact assessment in advance. They get the right to fix an issue if it comes up, and collaborate with the Attorney General to get things right. And that's really important to us. And there is no private right of action in this bill either.
Definitely. And I thank the makers of the bill. I really do. I think it's something extremely important. But it's just as far as some far off board or entity of people that are deciding what's reasonable and these, I just want to sort of delve into that a little bit more. But thank you very,
Yeah.
very much.
Yeah, thank you.
Absolutely.
Seeing no more questions, I believe that concludes this panel. Thank you very much.
Thank you.
Next panel we have is Christine McComas, Mia Minor, and Todd Minor. Yeah, cool.
Good afternoon. My name is Mia Minor. I'm here with my husband, Todd Minor, and our family to advocate for the passage of the Maryland Kids Code Bill in the House and Senate. First, we want to thank bill sponsors, Senator Ben Kramer, Delegate Gerard Solomon, and Delegate C.T. Wilson. By sharing our story, we hope to help keep our children and families from going through the tragic events we have experienced and endured. Our son Matthew Emmanuel Minor, Matt was his nickname, was a very loving and compassionate child. He was a big hugger. Matthew had a very charismatic and loving personality and had a wonderful smile that would light up the room. He cherished his time at our family gatherings, especially those at the home in Tappahannock, Virginia. On the evening of March 7th, our world was devastated and forever changed by the death of our son, Matthew, as a result of the blackout challenge on YouTube and TikTok. We ask that you pass the Maryland Kids Code Bill without delay. So other families do not have to endure the tragedies our family has to face due to unrestricted social media. Matthew 5:9 states in the Bible, "Blessed are the peacemakers, for they will be called children of God." Thank you for your time and for allowing me to testify today.
Greetings today to the honorable and esteemed members of the House, this committee, Mr. Chair. My name is Todd Minor, Senior. As my wife stated, we're here to advocate for the passage of the Maryland Kids Code in the House. First, we thank the bill sponsors, Senator Ben Kramer, Delegate Jared Solomon, and Delegate C.T. Wilson, who have shown their continuing commitment to online child safety. We also want to thank our partners in advocacy, the Five Rights Foundation, Parents Together, and Fair Play for Kids. By sharing what we've gone through, we hope to illuminate you to the dangers that social media imposes on the children in our state, including the devastation in the wake of losing a child. On the evening of March 7th, 2019, we found our son Matt unresponsive with something around his neck. I was trained in CPR in the Army and began administering it to Matt, and Mia called 911. I was trying to breathe life back into my child. Can you imagine the horror we endured that night and continue to live with? The vision of Matt's death is forever burned in our minds. Unfortunately, it will never go away. We live with it every day. But today, in these hallowed halls, you can do something so this does not happen to another family. I'm sure you agree that another family should never experience this ever. We join forces with other parents, educators, mental health professionals, and other concerned community members to support the Maryland Kids Code Bill and similar legislative efforts nationwide, becoming voices in a growing movement that seeks to hold tech companies accountable. We ask you to support and pass the Maryland Kids Code Bill. If such laws, such as the Maryland Kids Code, were in place, this tragedy would not have happened to our family. Let us tell the rest of the country in a loud, unanimous message that Maryland values its children's online safety above anything else. Thank you so much for your time and allowing me to speak.
Good afternoon, Chair Wilson, committee members. My name is Christine McComas. As lifelong Marylanders, my husband and I raised 4 daughters. Maryland's anti-cyberbullying criminal statute is named for our daughter, Grace. Grace's sisters are now all strong, independent, and successful adults, but our beloved Grace Catherine is forever 15, having died by suicide related to death-wishing and hate-filled cyber abuse over social media. You may remember that Grace's Law was passed unanimously in 2013, and in 2019, Grace's Law 2.0 was passed to cover the ever-changing digital dangers, including sextortion, suicide baiting, and more. Grace never had a smartphone and wasn't even on Twitter, but didn't need to be harmed. I hope you'll take the time to read my longer testimony and the malicious abuse aimed at a child. Over the past decade, I've come to know parents with tragic stories from around the world and regularly get messages through her memorial page from other Maryland parents struggling to protect their own children online. Right now, even the most engaged, best parents are unable to keep their kids safe online. Secret until recently, algorithms are push-feeding dangerous and psychologically damaging content towards our kids, while platforms are designed to addict and keep them online for longer, driving up profits with little care for the collateral damage. By the age of 13, an average of 72 million data points have been collected on each child. And in 2022, social media companies earned an astonishing $11 billion by selling ads targeted to those kids. Joined by other grieving parents, 2 weeks ago, I attended the hearing on Capitol Hill, where senators called on Mark Zuckerberg of Meta and the CEOs of TikTok, Twitter, Snapchat, and Discord to account for their harms for children. There was a lot of empty, misleading talk, and you will undoubtedly hear their well-paid lawyers that are here today in the room who represent all the biggest platforms on the planet spin a similar tale. Don't believe it. This legislation is desperately needed and there's no time to wait. Maryland families deserve these protections now.
Well, as a parent, and I really say that your unmatched courage to share your tragedies and hopefully make something good out of what you deal with every day. I can't imagine. I just want to say thank you. I know it's difficult. I take that back. I can't imagine how difficult it is, but we are a house of action. I want you to understand you were heard. And we plan on doing something because but I just want to say thank you for sharing your horrific and tragic stories to try and make a better world for us and our children. Seeing no questions. You guys are good. Thank you very much. Thank you all very much. Christina Green, Laura Stewart, Lauren Lamb, and John Willems.
Hello, Mr. Chairman Wilson and members of the committee. My name is Christy Green, and I'm the Executive Director of Maryland Coalition of Families. I'm testifying today in support of House Bill 603, submitted as also our written testimony. We served over 4,600 families last year with family peer support across the state. Nearly 70% of the families served had children who struggled with behavioral health challenges. I'm here to represent today these caregivers, their voices, who quite frankly are exhausted and can't keep up with the fast evolving technology. As one parent shared with me during COVID, it was easier to let her child talk to friends on FaceTime and socialize via Roblox and other platforms. Oftentimes when bored, they would watch online videos or shows. She said, as parents, we tried to keep an eye on the amount of time and put restrictions on content. But their family found out the hard way that even if there are filters on their devices, TikTok videos would still pop up with inappropriate content that was oftentimes sexist, racist, and not inclusive. Inappropriate ads would find their way in. Oftentimes, the content was created with popular animated characters that had sexual innuendos, violence, and death, but were not restricted through the filters because it was animated. There were random short clips of characters suffocating each other or causing harm and violence. She shared that they saw behavioral changes in their two young children. As parents, they would try to set perimeters, for example, watch videos on kid channels only, etc. However, something else would inevitably pop up. Once a child sees something, it cannot be unseen. For children that have behavioral health challenges, it felt easier during the height of COVID and post-COVID that they were making social connections through gaming and other social media platforms, but it has been a slippery slope and a strain on their family. One of our youth engagement coordinators, Olivia, who's 20 years old, also submitted a powerful written testimony in your packet. I respectfully urge the committee for a favorable vote, and thank you for letting me testify today. That is all.
Hello, my name is Laura Stewart, and I am representing the Free State PTA today. The statewide PTA, which consists of 70,000 volunteer members and families in over 500 public schools. I'm here in support of House Bill 603, the Maryland Kids Code. Before I start, I want to give my sincere condolences to the families that shared their heartbreaking stories. I heard those stories and thought about my two boys, and I'm so thankful they survived so far through the digital landscape. Parents are very aware of the dangers that come along with the benefits of the digital world. While it is impossible and likely undesirable to control all aspects of a young person's journey in the digital age, we can offer guardrails that make it less likely that they will be exploited and harmed. For this reason, we enthusiastically support House Bill 603, modeled after successful legislation from the United Kingdom, with California and other states following suit. This common sense legislation requires technology companies to follow best practices and protections that should already be in place around data collection and sharing, privacy settings, and transparency. HB 603 will place the onus on the technology companies to show that they have the capability to implement these shields. The requirement for companies to produce data protection impact statements will give parents the information they need to help guide their kids through the digital world, and will encourage companies to protect kids' digital footprint. The bill will also protect collection, use, storage, and disclosure of kids' personal information, including geolocation data. School systems will be able to use these data protection impact statements when partnering with companies who provide digital materials. For instance, Navient and College Board's usage of children's data has long been a concern of parents. There has been too much harm done to kids in the name of profit. Families need companies to step up and prioritize children's safety. And this bill is a step in the right direction. And for that reason, Free State PTA urges a favorable report for HB 603. Thank you.
Mr. Chairman, members of the committee, John Willems, representing the Maryland Association of Boards of Education on behalf of all 24 local boards here today in strong support of House Bill 603. MAPE supports the bill for the reasons that you've heard described by other individuals and organizations testifying. Want to emphasize that the bill will provide meaningful assurances to families and communities and the state as a whole outside of the school environment that our children are reasonably protected from the harmful effects arising from their online activity. Specifically, the bill would require strict privacy protections for online products, prohibit data collection and sharing practices, require these businesses to document the risks associated with their online products likely to be accessed by children, and establish a duty for businesses under this law to act in the best interests of children. This bill is very important to govern the online access and use of data collected from children across the state. But I do want to emphasize that In the pre-K-12 environment, we are a step ahead relative to student data privacy. In 2015, the legislature enacted the Student Data Privacy Act, and in 2019, they followed suit and established the Student Data Privacy Council. So with regard to the education setting and any vendor providing an online service or product to Maryland's public schools, we ensure that there is no collection of data and targeted advertising based on that data. So that's certainly, I think, worth noting and a testament to this body's commitment to ensuring the safety of our students. And this bill would broaden the net considerably to protect all children across the state. Thank you.
Chair Wilson, members of the committee, thank you for having me. My name is Lauren Lamb. I'm a former high school teacher, and I'm here on behalf of the Maryland State Education Association, which represents 75,000 public school educator members across the state. We strongly support House Bill 603. Educators know that students' learning is affected by their experiences outside the classroom, and increasingly social media is central to those experiences. Last year, a Gallup poll found that the teenagers they surveyed were spending nearly 5 hours per day on social media. We have lots of research showing that this affects students' self-esteem and mental health, and educators see those impacts in the classroom every day. Online platforms can be valuable. Lots of educators use them for learning purposes and for classroom engagement. But too many students are suffering the effects of unregulated social media, including invasive data collection, online harassment and bullying, misinformation, and features designed to be addictive. This bill represents common sense regulation that would keep kids safe and healthy without restricting their access to information. We urge you to issue a favorable report. Thank you.
Thank you, Mr. Chairman. Thank you all for your testimony. I think we can all agree the intent of the bill is honorable, but there's actually a section here that really bothers me. It's on page 19 and 20, which says a covered entity may not allow a child's parent, guardian, or any other consumer to monitor the child's online activity or track the child's location without providing an obvious signal to the child when the child is being monitored or tracked. I actually would have thought that would have read the opposite of that they may allow. And Mr. Willems, I was actually kind of curious, what is May's position on that as far as parental involvement or oversight of their child? Online activity.
Yeah, MABE does not have a position on that specific provision of the bill and would be very interested in following up with you on your concerns related to that bill. As you know, MABE is very committed to parental engagement with their local boards and with the school system and educators, and so would be interested in following up with you on that.
Great, perfect, thank you. It's on page 19, section 14-4606, where it says a covered entity may not, and then it lists 9 items, and the 9th item on page 20 says the covered entity may not allow a child's parent, guardian, or any other consumer to monitor the child's online activity or track the child's location without providing an obvious signal to the child when the child is being monitored or tracked. I thought it would read that the covered entity may allow a child's parent, but it says they may not allow.
Please go ahead.
Being monitored. That way there's no secret tracking. I think that's all that provision, at least if I read it correctly, says. We can debate it more later, but it's a good point. I think.
It's a good point. We just got to figure out, I mean, there's some balances. I think that the issue is basically like Google Maps. when you stalk your kids, which we often do, it sends your kids notices that, hey, your parents are looking at you, your parents are tracking you. I think Apple, a few of them already do the same thing. Again, I don't believe anybody thinks the intent of the bill is to prevent your parents from tracking you or, tracking you online or your online activity. So we'll look at that to make sure the language is correct, because I don't think we're in disagreement here. And I guess, and we can argue whether you should notify your kids whether they're being tracked or not. I kind of agree with you. They don't need to know if I'm paying for the phone, but I guess we'll talk about that. That's what we have committees for. Thank you for pointing that out, though. I appreciate that. I don't see any questions, so thank you guys very much. And again, great question. We'll move on to our next panel. Thank you guys very much. Stephanie Erdice, Ellie Mitchell, Linda Boyd, Arlene Gaismar. Oh, Ariel Gaismar, I apologize. Again, Stephanie Erdice, Ellie Mitchell, Linda Boyd, Ariel Gaismar, and Hannah Abrams. Oh yeah, we weren't going to let the other person testify. I think she knows she's not welcome here. So please, you can have a seat. We don't
Deferring my subject matter.
I need a bodyguard.
Right. We don't let quitters testify. So whoever's ready, go ahead.
I'm Linda Boyd. I'm here on behalf of the Episcopal Diocese of Maryland. I would echo everything everyone said. You've heard the reasons that we would support this, but as faith leaders, we believe that every child is a child of God, as is every other human being, and that each child deserves protection against just exploitation, discrimination, etc. So I won't go on. I think you know why we support this bill, and we applaud you for tackling it. Thank you.
Good afternoon, Mr. Chair, Mr. Vice Chair, and members of the committee. I'm Stephanie Erdice, Associate Director of the Maryland Coalition Against Sexual Assault. I'm here at the direction of our Director, Lisa Jordan. CASA is the coalition of the rape crisis centers across the state of Maryland, and our organization includes the Sexual Assault Legal Institute. CASA defers to other witnesses regarding the technology. We are not experts in technology, but we are experts on preventing and responding to online sexual exploitation and harassment of children. This is an enormous problem in our state and for our children, as you have already heard. Leading research states 40% of children report they have been approached online by someone attempting to befriend them or manipulate them. The National Center for Missing and Exploited Children reports that since 2012, they've seen an 8,000% increase in tips to their cyber lines. This includes 80,000 reports of online enticement of children for sexual acts and 32 million reports of child pornography. Adhering to punish criminals for soliciting children to send them images of their intimate body parts, the Maryland State's Attorneys Association reported, it is a common practice for an online perpetrator to encourage a youth to manufacture child sexual assault material and send it to the perpetrator. Conversely, the perpetrator frequently sends pictures of their own genitalia to the minor. Criminal law in Maryland creates penalties to punish these offenders, but HB 603 would help prevent them. CASA strongly supports House Bill 603 because the Kids Code will help prevent crime and support our kids, protecting them against sexual perpetrators and sexual exploitation. For these reasons, CASA requests a favorable report on House Bill 603. Thank you.
Chair Wilson, Vice Chair Crosby, committee members. My name is Hannah Abrams, and I'm here on behalf of the Consumer Protection Division of the Office of the Attorney General. Thank you for letting me speak today. House Bill 603 asks businesses that offer online products or services to children to consider the impact that the product will have on those children. We know that companies regularly analyze the impact their products have on their users, and we have seen companies explicitly ignore harm to children, sometimes with deadly consequences. This bill narrowly tailors its regulation to directly advance the substantial governmental interest of protecting children by requiring platforms to assess any negative impacts that their products might have on children, prohibiting profiling by default, and limiting the processing of children's data. In addition, HB 603 prohibits the use of deceptive design patterns that mislead and confuse underage users. We support the substance of this bill. We do have 3 amendments that will conform it to Maryland's existing consumer protection regulatory scheme. First, the bill introduces a new and separate penalty structure. The Maryland Consumer Protection Act already offers penalties that are more robust and offer more flexibility than the penalties proposed in HB 603. There's no need for to create a new framework, and it's simply inefficient. Second, we recommend removing the right to cure. It's an unwarranted and unnecessary grace period, which would fundamentally alter and restrict the authority of the division, dilute our ability to protect Maryland consumers, and impose a significant administrative burden on the division. Third, we recommend including the opportunity for individual recovery pursuant to the Consumer Protection Act. Given the potential significant and individualized harms that we've seen in the connection with children and social media, we believe that parents should have the ability to pursue a remedy where children suffer actual harm. These amendments, we urge favorable report.
Mr. Chairman, just here for questions.
We're done with the favorables. We're moving to the unfavorables. We have Carl Szabo, Alan Combs, Rebecca Schneider, and Camille.
I have
Fleisch.
informational.
Oh, just in case there are questions, come on up anyway.
Do you want the informational or the unfavorable to go first?
We'll let the unfavorable go first. Please, ma'am.
Good afternoon. Thank you, committee. My name is Rebecca Snyder. I'm the executive director of the Maryland Delaware DC Press Association. And as currently written, it's unfortunate that we have to oppose House Bill 603. You know, we really appreciate some of the changes that the sponsors made last year to make the bill less content focused. But there are news media is not social media. And so I think, and we understand that children need, the children need to be protected, and it's obvious from favorable testimony that that's the case. However, the language in many of these, in many of the bill's instances is overbroad. And so when I look at how do we comply with this to have these vague standards and who decides who's in compliance and who's not, it comes into a confusing puddle to actually make sure that we are compliant when we're not really the focus of this bill. So I'd prefer, you know, if we could, we would ask for a news media exemption. Barring that, we've listed out a few amendments that would help get clarity on some of these points. And so I respectfully urge the adoption of those amendments, and if not, then an unfavorable report. Thank you.
Thank you, Chair Wilson and members of the committee. My name is Alon Sean Calms. I'm a director of state and local public policy for Chamber of Progress. Chamber of Progress is a progressive technology trade group. We have corporate partners that do include companies like Google and Snap, but our partners do not get a vote or veto over any of our positions or statements. While we support the aim of keeping children safe online and think this bill is well-intentioned, and we do appreciate the attempts to amend the bill, we are still opposed to the bill because we worry that there may be several unintended consequences. First, we worry that the way the data protection impact assessments could actually chill development of new products and features that could improve safety for children. Second, we worry that the bill could lead to over moderation of content due to the bill requiring websites to implement measures to prevent the risk of children experiencing physical or financial harm, psychological or emotional harm without necessarily providing clear guidance about what that might entail. Third, we worry that the bill, even with the amendment, would still require age verification, which runs counter to common privacy principles of data minimization. Lastly, I would like to note that just yesterday, we actually sent a coalition letter further outlining these concerns that included other groups, including LGBT Tech, the Woodhull Freedom Foundation, the Trevor Project, and the Maryland LGBTQ Chamber of Commerce. Thank you so much for your time.
Sir, before we go further, I just, you brought up some interesting topics. I have some questions. Could you explain to me the the tech for the LGBTQ community? What's the issue of concern for that?
So our primary concern there would be the definitions around harm and how that we believe that's overly broad. We worry that, this could potentially, the bill could potentially incentivize companies to over moderate. So they might take off content related to, say, trans issues or LGBTQ issues in order to try to avoid causing any kind of vague harm to children.
Are you saying that that's something that the company may do on its own? Or is that what you say the bill requires them to do?
We believe both, sir.
You believe that this bill in its current form would require them to take off any LGBTQ information?
We believe the companies would have a strong incentive to do so.
Interesting. Obviously, because that's not the intent of the bill. I'm sure you've heard that before. And all right, that's interesting. And the age verification that's problematic because.
So I believe the other sponsors, Delegate Solomon referenced this. They changed the language last year to age assurance. We worry that it's unclear how you would go about performing this age assurance. In some other states where they've attempted to do similar things, that might require submitting a driver's license or a credit card. And we worry about that and how that might impact privacy.
So, but you understand that they leave it to the companies to figure that out themselves, correct?
Yes, sir. But we worry about the vagueness there too, and worry that that still might be overly broad.
So we shouldn't be concerned with the age of the individuals viewing the technology.
I think it's still a concern. Like I mentioned, Chamber of Progress still does favor trying to make the internet safe for children. I will note that this is fairly different from the federal standard COPPA, which requires actual knowledge. COPPA is actually currently under, I believe it's open to federal comment. And one of the things they are considering is potentially changing the age from 13 to a different age.
Yeah, I just want to make sure. So you're saying you do agree that we should protect kids of a certain age? Or are you saying age should not be an issue when it comes to viewing online content?
I'd be happy to, if you had alternative bill text, I'd be happy to look at it. And
I just think we're stuck at a point where you either have to piss or get off the pot. I don't know any other way to say it. We're going to have to do something. I don't think we can pretend that because it may be vague or not vague enough, or then we have to kind of sit still. So that's why I'm trying to nail this down. Your concern about the age verification. So basically, if we just said, I guess the concern is, having somebody, the question as when Brian goes on some of those websites, they ask, is he 18 or older? And if he says yes, they check it. But the point being, the concern is, well, any kid could do that, right? So that's not really good faith because you know that any kid who wants to access it is going to lie. So I believe the goal, when I say I believe, I'm part of the bill, was that you guys who are way smarter than we are, way smarter than at least I am, Jared's a genius, will figure out ways beyond taking people's data to verify it. Even if it's just viewing let's say a driver's license and then deleting it. Because when people send me my information from my law firm, I delete it very quickly. Once I've got what I need, I don't use it, I don't store it. That would be that good faith argument because I don't want to be frozen here. And it sounds like the issue of age, you want us to pretend that that's not literally the elephant in this very room. And I don't really know how do we get around that. I'm down with saying send your driver's license in if you want to prove you're 18 and it's immediately deleted once we verify that face, that name, or that driver's license number. You're saying that that may be a data breach, correct?
Well, I believe if you required the companies to collect, say, driver's license, for example, and I want to say I appreciate everything that you had to say, Mr. Chair. If you required companies to, say, collect driver's licenses, they would be required to collect more data, which makes them a bigger target for hackers. And one of our privacy principles is we are generally in favor of data minimization.
Well, but you understand my point. We can't do nothing because there's for that very reason. That's why I guess I'm just stuck on, like when you talked about the LGBTQ and we're relying on your clients to figure this out because you guys know way more than we do. And believe me, if it's one thing I know is you guys already have the answer to this. That's why I'm a little furious because I know you know the answer to the way to verify it. I know you know the answer to make sure that trans and LGBTQ people are not harmed. This is just you're putting these roadblocks out here because that was the whole point of this bill is to not command, not dictate, because many times as elected officials, no offense to my vice chair, we step into issues that we know nothing about and we command people to do things that we may not have an expertise on, but you do. And so now what we're trying to do is put it back in your lap and instead of saying no, say, well, let's see what we can do. Let's see how we can, we're asking you to participate. And that's, I guess, the biggest fear with myself and Delegate Solomon is you guys are just going to stonewall like, well, if you don't tell us what to do, we'll do nothing. And I would say that would make you a very bad community member. What I'm asking, what I'm imploring and inviting is for you to come in and say, look, I understand this age verification is difficult. However, the genius back in the lab thinks we can do it this way. Same thing with the LGBTQ individuals is that's going to be defined by the individual company, whether they think it's harm or not. We're letting them do that. We're not saying we're not drawing a bright line because we want kids protected. What I don't want to hear, and what I will say very clearly, is no is not going to work. You better have a butt behind it. Otherwise, it's going the way it's going. And I say that because I get incensed when I hear things that seem like very simple issues that I might know the answer to, but damn well sure you know the answer to. And if you don't, I bet you can find it in 5 minutes because you have a lot of geniuses working for your client. And I expect something more than just merely stonewalling. And I feel like I'm being stonewalled. So let's go to the last issue when you talked about the chilling effect. What was the chilling effect again?
That's sort of one of the issues that we've gone back and forth about, the content moderation issue. And sir, I'd like to apologize if you feel that we're stonewalling.
You don't need to apologize, brother. You're doing your job, and so excuse my tone because you heard some of the other people testify. Please don't apologize. I know you're doing your job. I'm trying to send you back with something to talk to the client about. You know, plus my pistivity doesn't hurt. But I say that please, you're not offending me at all, and I'm not joking. You're not offending me by doing your job. I'm a defense attorney. I know what I have to do. I'm just saying, I'm letting you know the voice from this committee, myself and many other of my colleagues, we don't want to hear stonewalling. So you definitely don't. You're not offending me. I promise you.
Sir, I would like to just add very briefly, we have actually been in favor of another child privacy bill proposal in Virginia that specifically it focuses on targeted advertising and geolocation. I'd be happy to send that bill over to your office if you like.
I appreciate that.
For further discussion.
And I don't want to put you on the spot, but brother, you took the stand. You know how that goes, right?
Of course, sir.
You got to take the lick. So, but the last one was the chilling effect. What was that again?
The data protection impact assessment.
You started off talking about a chilling impact on development. I think for moderation of content.
Yes, and potential development of new features.
Yeah, that basically if we tell people to look out for kids, that somehow might slow down or stop them from developing new content.
I think the worry here, so I'd like to note that a number of the platforms have been working on developing, more age appropriate features. For example, YouTube has YouTube Kids. I think the worry here is that because all websites could potentially be accessed by a child and all websites carry a non-zero risk of harm to children, part of the data protection impact assessment could effectively chill services trying to develop new services because they would be worried about the non-zero risk of harm to children.
So you're worried about the innovation. So I'm sure you would agree, though, that if we had to decide between innovation or a child's life, we would probably take the child's life, right?
Of course, sir.
Thank you. I appreciate that, sir. And thank you for your testimony. Next, please.
Yes, Carl Zabo, Vice President General Counsel of NetChoice. I'm also an adjunct professor at George Mason Law School. My company also, I can tell you with absolute certainty, and unfortunately as a Maryland resident, a Maryland parent, my wife is a child therapist, so she's on the front lines of these issues. An unconstitutional law will protect zero children, and that's exactly what we're looking at right now. Basing a law on UK rules, not law, rules and guidance, where they have no First Amendment protection does not work here in the United States. California tried to do an end run around the First Amendment. They lost. Their law has done absolutely nothing to protect children in the state of California. It's an unfortunate reality. So what do we have here? We have compelled speech. It's a violation. Delegate Howard raised an important point. Who determines reckless? Reckless is used 40 times in this piece of legislation. When we're telling people what they can and cannot say, what they must or must not say, the Supreme Court demands that we provide that with crystal clarity. Crystal clarity. There's also to whom it applies. Anybody over 25 million. Where did that number come from? Why not 24? Why not 26? Why not 100 million? Why not a billion? Why not 10 trillion? You have to provide evidence and background to explain why the scope of the legislation is. That's why in the state of California, the New York Times joined my company, NetChoice, in filing an amicus brief against the state's law. So we've got the unconstitutionality. One of the things, and this gets to the chairman's question and complete frustration. And I have frustrations too as a parent when it comes to social media, stuff like that. The other day, my daughter came home from school with a Chromebook. And why did she come home from school with a Chromebook? Well, because Montgomery County Public Schools decided that if there's another snow day, we are just going to do virtual learning. We are forcing our kids to take these devices into their hands from the school system on up. If we don't want cell phones in the classrooms, the school systems can take them away and say, you don't have to have a cell phone in the classroom. Finally, when it comes to protecting children from child sexual abuse material, less than 1% of all reports of child sexual abuse material even get investigated, less than 1%. 99% of instances of child sexual abuse material, including by our own state attorney general, go uninvestigated. We need to give them more resources. Those are real solutions that are constitutional and will do real protection today.
Lily.
Thank you, Mr. Chair, and thank you, the panel, for your testimony. I have a question for Ms. Snyder. If I heard you correctly, were you asking for exemption for the press?
Yes.
Okay.
I'm sorry, go ahead.
Because I'm struggling with this issue because I cannot remember a time when I'm reading, let's say, Washington Post, the Baltimore Sun, whatever established media institutions, that there was a time when I didn't see some kind of random ad pushed to me. So when media starts act like a social media, it's just an instrument for information in some ways, right? And they also get involved in pushing ads on their website that are entirely unrelated to the content that I'm trying to read. I found not only annoying, distracting, but I felt like I'm being targeted. So are you saying we shouldn't regulate them?
So I'm not saying that you shouldn't regulate. What I'm saying is that the focus of this bill really is social media. Supposedly it's not content. And so there are a lot of requirements and a lot of unknowns that you're asking news media to hew to when we don't target children, we don't advertise to children. The programmatic ads that you see that kind of travel, from wherever you are really third-party ads. Those are from, the Google and Facebook. Really, it's Google and Facebook. It's the big tech that do that. And so we would like to follow the COSA bill in this respect, which does have a news media exemption. We think that it's important. It sidesteps any issues around content that still seem to, even though the sponsors have amended the bill pretty substantially, so it's not as content focused, there are still First Amendment concerns. That's not my personal knowledge area. So I think that there's a precedent for exempting news media. And I think it's the right thing to do because it's not social media.
So let me follow up on that. These days, the line seems to be blurred quite a bit. And, what used to be just very top-down established media now is very democratized, right? So a lot of places can just push out information, even though they're not practically speaking social media, right? So it's like a wild west, basically, okay? And so how do you define news media? That's a problem for me,
Luckily, Maryland has already worked on that because if you all recall the digital ad tax fracas of a couple of years ago, which also would remind all of us that Maryland felt really strongly that they were on solid constitutional ground, and that suit was lost, and Maryland had to pay all the attorney's fees, and it was, as a Maryland resident, that was bad. So that has a news media exemption, and in that exemption, it defines what is news media, and that's a definition that we collaborated with the sponsor, Senate President Ferguson, on that definition, and so we're perfectly comfortable with that. There's also a definition in the COSA federal COSA bill that we would be comfortable with, but Maryland has a great definition. We may as well run with it, and that is something that we are always concerned about. In some ways, journalism is an act. It's not a blessing. It is a decree. It is sort of how you behave in the marketplace. And so in the definition that we have in Maryland, we feel comfortable if that were to be something that you all would consider amending to the bill.
Thank you, Mr. Chair. To the gentleman, is it Chamber of Progress? Is that right?
Yes, ma'am.
Yeah, thank you. So thanks for coming. I guess my question is, I think the broader point that you were trying to make is that there are LGBTQ young people, children who may actually find the sort of traumatic damage within their own homes and find community online, and that's the sort of safety for them and helps with their survival. Is that your point?
Yes, ma'am.
Yeah, so I appreciate that. And I guess my question is, similar processes to these are in place in the UK? And has it been your finding that has been stripped from social media in the UK? Like, is that the experience in the UK, that children who are seeking that kind of support and community are not able to find it because of some of these codes that are in place that are similar to this bill in the UK?
I appreciate the question. I am not a lawyer, but from what I understand, the United Kingdom, their implementation of this law is pretty significantly different than how we implement laws in the United States. So there's much more of a back and forth if a company might have, say, a violation. It's less punitive, feels like a harsh word to use, but maybe punitive than the American legal system.
Is that like the right to cure thing that we were talking about?
Yes.
Which is in this bill, which is in this bill? Which is in this bill?
Yes.
So that concept of like, we'll work with you if we think that you're off, that folks were concerned was not in the other bill, is in this bill. So that would be similar to what is happening in the UK?
I'm not a lawyer, so I wouldn't want to say.
I guess conceptually, I guess what I'm just trying to say, I think I'm trying to say conceptually, putting these kinds of codes in place and standards in place, it seems like in the one place that we sort of have to look to see how it's worked, it seems to me like they have managed to both keep children safe from truly dangerous content and keep children safe in the sense of creating that accepting community for those who are searching for that within the LGBTQ community.
I will say the UK law, I think, is still pretty new. So I think folks are still kind of assessing how it's going. I know that one complaint has been that age verification and age insurance.
But that's not what I'm not asking.
sorry.
That was the chair's question. I'm asking specifically about this question of, because I think that we all have a similar goal of protecting children in all aspects, both protecting children from the dangers and really significant dangers, death, and trauma, lifetime trauma, and protecting children who are seeking community and safety for their sexuality online. We're trying to protect both of those things. And I'm just saying the one place that we can see where they've sort of got this balance right, it seems like has figured out how to do that. Or there isn't evidence that what you're saying might happen here if we put this forward has happened there. Is that right?
I would say there's probably not enough data and research yet. I'd be happy to double check that and follow up with you.
That would be great. And my second question to the gentleman in the middle is not about that, but is about, so have you seen the Attorney General's opinion on this bill?
No, I've not seen the Attorney General's opinion on this bill. However, I have seen the rulings in the states of California, Arkansas, just yesterday in the state of Ohio,
So, okay,
all
so
of which were in favor of my company against this type of approach. And just
so
to
let
be
me
clear-
just ask my second question then. Do you think that the Attorney General in Maryland has access to those rulings as well?
I would say, I'm not going to speak to the mental capacity of the Attorney General, but I will tell you that I will tell you that this bill.
I'm asking if he has access to that same information.
I don't know if the AG has access
I
to
assume,
it.
I assume so. It's public information.
So ultimately, you're getting to the question of, do I think the Maryland AG's opinion saying this is constitutional?
I'm actually asking if you've had a chance to read it. I mean, you're opining that we all who depend on our Attorney General and many of us believe that this is constitutional. And anytime we make a decision like this, we're taking a risk, of course, and we are willing to take a risk in order to protect children in the state. But we generally go with what our Attorney General says. And so what I'm asking is, since you're coming and telling us that we got it wrong, and that our Attorney General got it wrong, I'm just wondering if you've had a chance to actually read what it is that he said, and if you want to point out to us where you think he got it wrong, and like you have the better understanding of constitutionality on this.
So I will say I have not read his opinion, so I cannot say whether he got it
Okay,
wrong or right,
so
but I
this
will
would be
tell
my
you
request.
based on the text.
This would be my request. Here's my request. Can you take a look at that, and then you can get back to me or anyone else that you want to share that with, and let us know how it is that you think that the Attorney General got it wrong. And I think the sponsors right there, the chair as well, they could provide that to you. Thank you. Thank you, Mr. Chair.
Sometimes I really love you. Sorry. No, definitely sometimes. I think you know that, but Delegate Ampray, please. Why have I love you all the time?
Thank you, Mr. Chair. I just want to follow up on some of the questioning that the good delegate from Montgomery County brought up to Ms. Snyder in regards to the blurred lines between between the media and social media. I'm trying to get a better understanding. You said earlier you do not market your product to children. Is that what you said?
I don't think it's active. Now, granted, every child who has ever had to write a letter to the editor, or the civics lesson, children, and we want them to interact, but news, is not rainbows and kittens. And so I don't think that the bill is meant, to focus on children that may find upsetting news about, pick your upsetting issue, in the publication or on the news website. I don't think that the bill is targeting that, but when I look at how I would guide our members to comply with something like this, it's spongy. And I know that sometimes it's not, you can't like dial it in to be like, okay, here's all of the pieces, but to say, reasonably likely to be accessed by children, by a significant number of children. Of course, that will change based on, how much circulation you might have.
Right.
But it would really help us all just to get a little bit more clarity on what is at stake here, and knowing, and that's why I go back to the media exemption. We're not the target here. We're not, we want all people to be engaged with their communities, and that often happens through news.
Right.
And we want that to happen at a younger age, but I also have children. I'm not getting my 10-year-old to like sit back with, their
Yeah, no,
news
I
media.
understand what you're saying, but the only issue I have with your stance is that I would say the media has been a heavy user of social media to push their product. So I'm trying to understand, most of the time when I get in breaking news, it comes through a social media feed. So I'm trying to understand if you're saying that you are not targeting kids, if you're using social media frequently to push your product, aren't you targeting a wider audience? So I'm trying to understand, how are you, you're speaking of if we're in 1996, where the only way to access a newspaper is holding it.
Right.
We know for a fact Twitter has become like one of the #1 uses of breaking news. So I'm trying to understand how you're differentiating yourself here.
So if they're reposting, or you have to be a follower on social media, that article is not usually, and I don't know every in and out of the marketing strategy of every publication.
Right.
So let's hope I'm not wrong.
And I was hoping you said it, because that's the thing I'm struggling with, because we know that the news is using social media heavily. So I'm trying to understand why an exemption would be there if we know that you all, if the product you are using is using social media frequently. But I'm happy to talk more offline about it. I don't want to dominate your time here.
We can certainly talk more. I don't want to hold up a long day for you all.
All right, thank you.
Chair, and what's the delineation mark between, I guess, real media and social media? Like, they have to be an accredited journalist? Is that what you're?
So honestly, I always think of it as, I'm less about format and more of substance. So,
Does that include opinion pieces? Because that's what the internet basically is, and you guys publish those along with op-eds.
we do, but they're labeled as op-eds. They're not, hiding as like our blog post from whatever. And so, and this is how I see it. So, and I get, these are complicated issues. I wouldn't say that I have a lock on everything. Let's put it out there.
Yeah.
So, when a news media when the Baltimore Sun or the Baltimore Banner has the article, so has the piece, the content, they may deliver it through a variety of channels. It may go to their app, which you have to download. It may go to their website. It may be the person who wrote it may post it on their social media. They may even put it on Instagram. The Washington Post has a TikTok channel now, but they're not, the content is not chasing you. I think the problem is, and what this bill is seeking to address, is the advertising streams and the collection of data. And we do, and smarter people than I can figure out how to make sure that you're collecting the appropriate amount of data. Because we don't want to get into a situation where you're collecting so much just to prove that you're, whatever. That doesn't make a lot of sense. And so what I'm looking for is a little bit more clarity and a little bit more specificity. And it is not comforting to know that we're not the target of the bill, but we're in the crosshairs, and that that at any point somebody could be like, oh, well, you're doing it all wrong. Let's go through this right to cure thing, but we're not really going to tell you, we're not going to give you the bar that you have to meet. We're just going to use this reasonably likely, significant, like what about profiling, and just so the points in my testimony. So that's really where we have concern, and we've had a lot of conversations with sponsors on this, because I don't want to oppose this bill. We don't really ever get involved in these types of issues, but I have to, just like Chair Wilson says, it is my job to advocate for my members and make sure that they're protected and can do their jobs.
I understand. I was just asking a little bit about what you thought personally as a journalist, I would imagine, correct? What that delineation mark would look like legislatively in statute, differentiating yourself between social media platform and people who report on topics of the day in social media platforms versus the accredited journalist, quite frankly. And I can see you raising, I'd be interested. I think you were talking about the courts a minute ago, but anyway, we've moved on. So I would like to hear what you have to say.
So I think
Wait, I don't believe there was a question.
Yeah, about the.
Are you asking an additional question?
Yeah, about the delineation between
I
social media news platforms and actually accredited journalist platforms, and how some of those accredited journalism platforms.
No, I understood that. That was the first question. Are you asking an additional question? Are you asking additional panel members your question?
Put his finger up like he had some clarification.
Oh, no, I understand, but it's on you, delegate. We panels here for you to interrogate as you see fit.
I'm not interrogating him.
I don't mean that. I understand. You understand my point. If you're not asking a question for anybody else, then we'll move on. If you are,
then we'll certainly move on. Please reach out to my office so we can have frank discussion. Thank you.
Thank you, Mr. Chair. So just to be clear, it seems like everybody up there agrees that there is actually an issue that this bill is attempting to address that needs to be addressed. Is that correct? Okay.
Yes.
And so with the exception of Camille on the end, the three of you are unfavorable on this bill. Is that correct?
Correct. Well, I am.
Is there a reason why you're not favorable with amendments? Yes. Why are you not, if you agree that this is an issue that we need to deal with, why are you not favorable with amendments to help resolve the issue?
And the reason is because that's like asking me to drive a car from Annapolis to England. It can't be done. This bill is fundamentally flawed from the constitutionality provision in and of itself. Bans on speech, compelled speech are inherently violative of the First Amendment. And unfortunately,
so what you're saying is there's absolutely no way, there's nothing that we can do to protect our kids? Because you just said earlier that we need to do something to protect our kids. And now you're saying there's absolutely nothing we can do. We might as well just throw it out and forget about it.
No, that's not at all what I'm saying. So
that seems to be exactly what you're saying. You should be favorable with amendments. If you're favorable with amendments and you come in and you help fix it. Right now, you're just saying no. To my chairman's earlier comment, that's just not acceptable to just say no. And that's what the three of you are saying is no, you should be up here with favorable with amendments.
So
I have no more questions.
Well, with respect to that, sir, the amendments I would have would be a gut and replace with something, for example, that would give more resources to the state attorney general to begin enforcing and investigating the child sexual abuse material that's going uninvestigated by 99%. Things that I would suggest and have suggested in my testimony include advancing legislation like what is on the books in Virginia and Florida, which requires digital education in schools as part of the course curriculum. So yes, I am happy to provide solutions, just this is not one of them.
And I just want to, like I said, I'm sure you could see the frustration and clearly, sorry. So I'm sure you could see the frustration in my committee because we're trying to do something. And so when people say, hey, don't do anything, or as you said, let's focus on something, let's go to the sexual predators. Good Lord knows if anything I know is that, versus that's not why these families were testifying today because of sexual predation. But I guess that those suicides we just don't do anything about that because of freedom of speech. I think, I guess that's a good thing about being a combat soldier. Sometimes when you're told you can't take the objective, you still try. And that's kind of what made America great because being told no is fine. Falling for it is the problem. So, hearing it and just giving up is the problem. I'll take an ass whooping in court, but I won't take one in my committee. And I sure as hell won't take one on this House floor because can't nobody here do that. And we have people here that are trying to find a solution. That's why you've had people damn near begging, well, dude, you sound like you're very smart. Give us something. But you heard the confines of what we're doing, but you're saying that the freedoms in this country are so great that we can't protect our children from predation, we can't protect them from bullying. We can't protect them from people just using their data to lure them in to where they won't stop looking on their phone. We talk about gambling addiction. We talk about drug addiction. We talk about mental health. And I'm sure every one of you would say, you've got to do something. But when we do something, they say, no, not that. Because I've learned, Teddy Roosevelt said, the best thing you can do is the right thing. Second best thing you do is the wrong thing, but the worst thing you do is nothing. And that's why we're here, because we're not going to do nothing, which is why we've had people say, well, what can we do? If you say, hey, gut the bill and work on sexual assault, that doesn't help, because this bill isn't just about sexual predation. It's about these very smart people who've learned ways and created algorithms to lure our kids into being distracted, into having a life online that's bigger than a life offline, and that therefore being basically chattel for these corporations. And we're saying we can do better. And again, we always love amendments. We love people to come in and give us amendments. When you say no, it moves you off that table. And I know you guys are aware. That's why I keep imploring you. When the speaker makes it a priority, it's really hard. And I guess, you know, in maybe 2 years, you could click your heels and tell us, you know what, you were right, because, you know, the Supreme Court struck it down. I've taken L's before, and I'll take them again. But that's what you're saying. You're saying that, you know, an unconstitutional law is no law at all because it has no effect. But trying nothing has the exact same effect. I can't explain that to the families that just testified. So again, my point was, and as was many good delegates here, then let us know what we can do to stop our children from being victims, from being commodities, from being preyed upon, not just by these sexual predators, but by bullies, by corporations, by people that are devastating their lives. And this is going to go on for the next few generations. And I just want you to understand it's not personal, but it kind of is, because we all have kids. And so we want to do something. So appreciate everybody's input here. I don't know if I shut everybody else down. And Andrea, I can't, is it blinking? Oh, you got to keep it. Okay.
That's okay, Mr. Chair. Actually, I guess at this point, I would say me too, because the one thing that we've sat here all afternoon and we've heard something, and some of you have been up here over and over again and have been here for a while. Everyone says that, yes, we need to do something until we tell you that you need to do something. And then all of a sudden it's no. So, you know, honestly, I'm just a little frustrated right now, and I'm following my chair. I have his back. If we got to go into battle on the field, I'm going with him, and you can best believe that. So with that, isn't it so? Isn't that so?
Seth, you good? All right. And if you do get some information, we'd appreciate that. You know, I know that your offline conversation, it is important too. I appreciate you for a matter of time though. Did I get everybody? I think we got everybody. Panel, thank you again. And I understand you guys had a very tough job, so please don't take, oh, I thought you wouldn't say nothing, girl. No, go ahead. Ma'am, please go ahead and talk. I'm sorry. Go ahead.
I might be the last witness on the bill.
Yes.
Here is informational. So good afternoon, Mr. Chair, Mr. Vice Chair, members of the committee. For the record, my name is Camille Fesh. Pleased to be here today on behalf of Google, testifying as informational. Google thanks the committee and sponsored Delegate Solomon for the opportunity to engage on HB 603. The company takes seriously the importance of providing positive and safer experiences for users across its products and services. That is why it builds age-appropriate products to align with kids and teens' developmental stages and needs, and offers settings and tools for parents and families to manage their unique relationships with technology. We appreciate the great deal of work that has gone into this bill by advocates and sponsors to create something durable that provides appropriate safeguards while enabling access to innovative technologies and high-quality, diverse content. We support the goals of the legislation and overall approach that is flexible and risk-based, but continue to have concerns about some of the impacts of some of the key definitions, such as best interest of the children and requirements in the bill. With a few target amendments to this bill that enable access to high quality content and help organizations of all types and sizes focus risk assessments on greater risk of harm, Maryland can establish itself as a national leader in online safety for minors. We look forward to working with this committee and continuing to work forward with the committee, Chair Wilson, Delegate Solomon, and the Senate sponsor on this critical issue. Thank you very much, and I'm available for questions.
Well, thank you for reading the room. I appreciate that. That was good testimony.
Thank you.
Go ahead when you're ready, ma'am.
Thank you, Mr. Chair and members of the committee. I'm Jordan Rodell, State Policy Manager at the Computer and Communications Industry Association. While we certainly support the implementation of mechanisms that ensure children's safety online, we would like to respectfully raise many concerns about House Bill 603. First, it is imperative to prioritize establishing a comprehensive data privacy law that provides baseline protections applicable to all consumers. This law should incorporate safeguards for sensitive data, specifically addressing information commonly linked to younger users. Next, the bill lacks narrowly tailored definitions necessary for compliance. For example, the definition of, quote, best interests of a child is vague and impossible to operationalize at scale, creating moving goalposts for compliance. Private online businesses will not be able to coherently or consistently make diagnostic assessments of users, including what content could be, quote, physically, financially, or emotionally harmful to them. Determining the best solution for the well-being of every young user engaging with content on an online platform poses a serious feasibility challenge, given the divergences based on lived experiences and age. To provide additional clarity from previous questions, CCIA interprets this bill as necessitating businesses to distinguish users aged below and above 18. However, there are pitfalls with age verification. As outlined further in my written testimony, several existing online age verification solutions fail to satisfactorily meet three key standards. 1, providing sufficiently reliable verification. 2, allowing for complete coverage of the population, and 3, respecting the protection of individuals' data, privacy, and security. Though the intention to keep kids safe online is commendable, this bill is counterproductive to that initiative by requiring more data collection about young people. To further provide clarity, the Age-Appropriate Design Code of the United Kingdom is not a law, but regulatory guidance rooted in a UN convention to which the United States does not belong. United Kingdom businesses processing personal data about UK children are not required to implement age estimations or other requirements in this bill in order to operate. Under US law, where the bill's language would be legally enforceable, covered entities would be forced to implement age verification measures to avoid potential liability. I appreciate your consideration of these comments and stand ready to provide additional information. Thank you for your time.
Thank you very much, ma'am. I do not see any questions, so thank you very much for your testimony. Colleagues, I believe that completes that bill. We have one more very brief bill. Delegate Lewis, House Bills at 645.
Thank you, Chair Wilson, Vice Chair Crosby, and the members of Economic Matters Committee. For the record, I'm Delegate Jazz Lewis, and I'm thrilled to have the opportunity to present for House Bill 645. In short, this bill sets out to protect children who are featured on monetized social media channels from financial exploitation. The bill also protects them from being excessively worked to produce content on monetized accounts, and finally provides them the standing once they reach the age of maturity at 18 to request the removal of content featuring their face, voice, and likeness that they don't approve of from those monetary socialized media platforms. This bill sets out to provide common sense guardrails for an industry that has exploded in value and in its prevalence. The influencer economy is inescapable and is daunting in its scale, generating billions of dollars of revenue yearly. Much of this value is generated on family video blogs, also known as vlogs, which heavily depend on children for their content. Despite their labor, children featured in these vlogs are not entitled to any of the revenue that their name, image, and likeness generate on these accounts. Under this new law, those managing these accounts must allocate a portion of their revenue to a trust fund for children regularly featured in monetized accounts. These trusts will be set aside for those children to control when they turn 18, ensuring that some of their revenue generated from their hard labor still exists when they are old enough to have a say over their body and likeness. This is the same thing that we do for child actors who are in TV and movies. But the influencer industry is so new that child influencers do not get the same protections as child actors when they undoubtedly should. The bill proposes to impose restrictions on the number of hours a child influencer can work, which will be capped at 8 hours, similar to any other industry that employs children. Additionally, the bill would allow former child influencers to request social media companies to remove their content when they turn 18, as stated. This bill is about preventing child exploitation in an industry built on the work of children. We have seen examples of those who are featured on these high-profile and very public accounts being exploited and even abused by family members, all under the guise of producing content that is streamed across social media. One of the first examples of this that we saw is actually from here in Maryland. The channel called Daddy05, where parents would film cruel pranks on their own children on camera. These so-called pranks amounted to abuse, not my opinion, but that of a court, and the parents lost custody of those children subjected to the abuse. This is an example from Frederick, Maryland, and at its peak, these videos were posted to a subscriber base of over 700,000. This bill is just one step forward to reform a potentially exploitative industry and protect children who are taken for granted and even often abused by those who should be looking out for their well-being. For that, I urge a favorable report. I'm talking to industry on the bill, and there will be amendments. Open to questions.
I see no questions. I do believe we have two virtual witnesses. Cam Barrett.
Hello.
Yes, ma'am. You go ahead and go. Thank you.
First, I just want to thank you, Mr. Chairman and ranking members of the committee for your time. My name is Cam Barrett, and I'm an international advocate who fights to end the exploitation of children on social media. As a former content kid myself, I know what it's like to grow up with a digital footprint I never asked for. As my mom posted to the world my first ever menstrual cycle, as she posted to the world the intimate details about me being adopted, her platform grew, and I had no say in what was posted. When I was younger, there wasn't necessarily a source to monetize each post. However, there have always been brand deals. In exchange for content, my mom received free concert tickets from Live Nation resellers who viewed her posts. After I was hit by a drunk driver, her connections said they would pay for me to go to see artists like Demi Lovato or Taylor Swift in exchange for promotional posts. At that age, I became vigilantly hyper-aware of my surroundings, developed an anxiety disorder I have to this day, and dropped out of high school. That's when posing became a full-time job for me. As we know, social media has drastically changed over the past several years in a way where it's much more accessible for parents to turn their children into a quick source of income. In these situations, most blogger parents will pull their children out of school so they have more opportunities. And I'll be the first to admit that it leads to a very quick burnout. As an adult, I'm still learning how to navigate this life with a digital footprint I can't remove. I've been diagnosed with complex post-traumatic stress disorder and an anxiety disorder that is so debilitating I'm unable to hold a job. Members of the committee, I plead with you to think about this generation of children who give their parents free labor to maintain a social media presence. Maryland has the opportunity to protect the child influencers who reside in this state from facing a monetized childhood only to be met with nothing in return at 18, along with having no say in a digital footprint they never asked for. Thank you for your time, and I'm open to any questions.
Great job, Keith.
A very good job, ma'am. Thank you very much. I do not see any questions, but thank you for telling us your story.
Thank you.
I guess we'll move on to the last witness, which is Chris McCarty. Go ahead, sir. If you can hear me, go ahead and begin.
Okay, thank you. Greetings and thank you to Mr. Chair, Mr. Vice Chair, ranking members of the committee. For the record, my name is Chris McCarty and I am representing the organization Quit Clicking Kids. I am offering favorable testimony for House Bill 0645. I want you all to picture something. A family gathered for a holiday, someone holding a camera and everyone laughing and waving. Years later, the people gather together and watch the video that documents their happiness. The children in the family have grown and they may be embarrassed of their younger selves, but the event stays in the family. That was then. Now imagine a similar family, similar but not the same. They're gathered for a holiday too, but this time someone pulls out a smartphone instead of a camcorder. This time the children who embarrass themselves must live with antics that will be recorded, shared, and may live forever online. The content shifts from home videos to grades, mental and physical health struggles, and even other compromising situations. This information is then used as clickbait to generate intrigue and revenue for a monetized family channel. These accounts are known as family vlogging accounts, and they diminish children's privacy by using these moments as clickbait. One family has even monetized the birthing video of their child, introducing somebody to this world who grow up in front of a camera, lose the privacy of childhood, and generate revenue for their family without a guarantee of financial compensation. This bill is narrowly tailored to only affect accounts of significant size that are making significant amounts of revenue, and this issue is gaining traction. I urge Maryland to be a leader in child safety and on tech policy. Thank you so much. I'm open to questions.
Thank you very much. I do not see any questions, but thank you for your wonderful testimony. All right, colleagues, I believe that concludes, what? Brief indulgence. We have, is there there's a Margaret Durkin here? Apologize. Sorry? Is she on? Signed up to testify. God bless it. But she's informational, so I don't know if she's going to testify. All right. Go ahead, ma'am.
Good afternoon, Chair Wilson and members of the committee. My name is Margaret Durkin, and I'm the Executive Director with TechNet, which is a technology trade association. We appreciate the policy concerns with this bill. However, as outlined in our written remarks, we do have a couple concerns with the bill as drafted. Specifically, we are especially concerned about the deletion request in the bill. It is unclear on specifics on how a minor turned adult would make that deletion request to the platform. And it may work for content hosted on a platform, but can't control individual users who have put content out into the public domain. A couple questions to consider with this deletion mandate is how to know if the minor turned adult is in fact the person who is requesting that the video be deleted. Another question to consider is that if a video has multiple minors and only one is making the deletion request, how does a platform go about doing that, especially if an account is a significant moneymaker for those minors, say, for example, to fund a future college expense? There's also the idea of privacy versus public interest. Sometimes vloggers will participate at newsworthy events where a minor's partial face could be pictured. And so we would like the committee to consider that. I have spoken to Delegate Lewis earlier today, and it's my understanding that he is working on some amendments related to a potential court option for a minor to turn to if they want to seek remedies. So we're looking forward to continuing that conversation with him. But for now, TechNet is unfavorable, and I'm happy to take any questions. Thank you.
Seeing no questions, thank you very much, ma'am.
Thank you.
I believe we have brief indulgence. We have unfavorable. Mary Aman.
Can you hear me?
Go ahead, ma'am.
Thank you. Thanks to the chair and committee for the opportunity to share information relevant to House Bill 645. My name is Dr. Mary Jean Ammon, and I'm an assistant professor at the University of Central Florida. I study how parents share their kids' information online, so I'd like to offer a research perspective on the topic. As we all know, it's never been easier to post pictures, video, and text to wide audiences. And indeed, the public reports being seriously concerned about how their information is shared on social media without consent. But surprisingly, it's not strangers' social media sharing that people are most concerned about. Research shows that the public is more concerned with how their family, friends, and coworkers share their information without permission. That's because those familiar others have increased access to our most intimate moments and personal information. And those are the types of privacy violations that children are especially vulnerable to, those that occur in the home, with potential privacy risks of parental sharing, including bullying, harassment, identity theft, sexual predation, and having a permanent digital footprint that is at odds with their future values. Research shows that parents who share the most information about their kids online tend to do so in larger, more public networks. They expose their children to social media at earlier ages, have higher levels of social media addiction, and greater confidence in their parenting. These research findings indicate that some parents are outliers in how they are sharing and profiting from their kids' information. And it's those outliers that the proposed legislation aims to address. Relating the research findings to US legislation, there's a well-known history of child exploitation in the entertainment industry, and we now have widely adopted laws to address those cases of parental financial exploitation. However, with modern entertainment platforms like social media, we need to take seriously that child influencers need protections and that current child exploitation legislation may be out of date. Thank you for your attention to this topic.
Ma'am, thank you very much. Seeing no questions, that concludes this bill hearing. Thank you very much for your testimony, ma'am. All right, colleagues, that concludes the bill hearings for today. Look forward to seeing everybody tonight. We have an event at 6:30. Steve, you gonna let me down? Okay. It's 6:30. It's 6:30, guys. Luna's tonight, so we'll see everybody then. Thank you very much. I don't know.